May I please, Your Lordship?
Yes.
I beg to mention item number 29 and 30. My senior counsel,
A bit louder, please. I can't hear you. Item
29 and 30. Senior counsel referring from NES.
We have received a case diary, but up to that CD is required. Lord. So up to that CD, we have sent back the CD and updation.
as prayed for by learned counsel for the petitioner. Place the matter again on when?
After 1 week.
Give a date. In the meantime,
Is an interim, Lordship.
PP learned PP to obtain up to date CD.
2011.
Interim order passed earlier to continue.
Yes, Lord.
Yes.
So I beg to mention item number 4 and 5, Lord. It may
4 and 5, yes.
it may fix next week, Lord.
Motion.
Some Lordship. But Lordship, I am appearing on behalf of S. Raman and he is for whom filed with Lord.
Okay. All right. Next week, give a date.
Maybe fix of 10.
Wouldn't it have been better to call for the CD in the meantime? By the time he recovers. Anyway, that is your prayer. Please give a date.
December, Lordship.
10th of December.
Sorry, Lordship. 10th of November, Lordship. Sorry, Lordship.
Okay.
That's November.
Obliged, Lordship.
Yes.
Lordship, I beg to mention item number 30.
30.
13, sir.
13. Okay.
Lordship, my senior counsel is out of station. Date of his close relative. So matter may be listed in
Yeah, give a date.
maybe tomorrow or day after.
Tomorrow is a holiday.
Holiday day after.
Yeah.
Yes.
My pleasure, Lord, sir. So I beg to mention item number 21,
2-1.
2-1.
Yes.
I'm saying for adjournment for that day only. Next week.
Yeah, give a date.
Next week.
We have received a case diary, Lordship.
CD received to be retained.
Lordship. Must.
Yes.
Can have 12, my lord. 11 is
All right, 12.
12.
May I please, Your Lordship?
You are?
I'm D. Soikia. On behalf of D. Soikia.
Mr. So on behalf of Mr. D. Chotia. Praise for withdrawal of the case. Accordingly, case is dismissed as well as on.
Obliged.
Please, Your Lordship. My lord will find the FIR in page 19. May I read the FIR, Lordship?
Yes.
With due reference to the subject cited above, I have the honor to state that on 16/10/2025 at around 5:20 p.m., while the team from New Bongaigaon GRP Investigation Center, namely so-and-so, Nitul Deka, Sanjeev Dole, Rohila Basumatari, headed by in charge New Bongaigaon GRP Investigation Center, including me, were conducting the routine checking in New Bongaigaon railway platforms. A person was found at the platform number 1A, who was loitering and he had a bag. We got suspicious and we checked the bag. A piece of golden metal port shape was recovered from the bag. The person is identified as Manoj Diggal, aged 47 years, son of late so-and-so, resident of so-and-so. The person has been apprehended by in charge New Bongaigaon GRP Investigation Center, as well as the above piece of golden metal have been seized. On interrogating, the above accused person has admitted that he was making an effort to sell the above piece of golden metal in somewhere showed it as pure gold. It is also suspected that he, along with some fraud, conspired to cheat people by way of making fake gold as genuine. Now, my lord, my submission is that, my lord, even a perusal of the FIR will not reveal any cognizable offense. I say so because, my lord, 3184, that is the corresponding provision is 420. Some person has to be deceived. There has to be a victim.
I think this is the second case of gold. I think gold boats are circulating nowadays. We had a previous case also. One fellow from Rajasthan, he came
Yes.
to Assam and bought a gold boat, supposed gold boat. Anyway, but since the FIR does not disclose any cognizable offense, we'll grant him interim now. Since 16 October, okay, right?
Yes,
Date of arrest.
from 16 October. 19 days is the.
Had learned counsel for the petitioner. This is an application under so and so. As per the FIR, it appears that the petitioner was arrested merely on suspicion. Call for the CD. It is further directed that the petitioner shall be released on interim bail of rupees 20,000 on security. In connection with the aforesaid case to the satisfaction of the learned Elaka magistrate. List again on
2011. What shall we? 20.
Pilot 102, pilot. Pilot 10, the section is 103.
CD.
Lordship may call for the case here if it is.
Now,
My God.
give a date.
1911. Lordship.
Oblige me.
Mr. Lordship. Miller, I'm here on behalf of Mr. A. Sharma. Miller. Well, this is a chart-fitted case. What has happened? Petitioner Paper Lordship is a doctor. Lord, he met the informant through Facebook. And Milord, they exchanged numbers and Milord started. Now, what has happened, Milord? On his way to Gwalpara, he called him up and asked him to go there. Now, thereafter, Milord, he was detained. And Milord, he was forced to get married, Milord. In fact, the Kaji was supposed to be brought in the next day. Thereafter, I lost an FIR, Milord. My FIR is at an earlier point of time, Your Lordship. And in fact, Milord, my FIR of Your Lordship kindly comes to
Your
page
FIR is at page?
21. This is Milord.
Dr. Salim Atik Rabbani.
Yes, yes, Milord. He's a medical.
And you are the petitioner also.
I'm the petitioner. Now, what has happened, Milord? After I lost the FIR, Milord, the girl, Milord, she also lost an FIR. That is subsequent to my Milord.
So, what is the FIR of this case?
This is Your Lordship will find it. Page 30 starts at 35, Milord, and relevant is at 37. Both the cases have been charge sheeted, Milord. This is Gwalpara 166. Mine is Milord 155. The incident, Milord, LS incident occurred on 17/7. FIR lost after a month. Milord.
Yes, yes, page, your page. Present FIR.
Present
Page?
page 37, Milord.
37.
337.
Both FIRs lodged on the same date.
Same date, Milord, but Your Lordship kindly sees the time of filing, Milord, page 35 is her FIR. Information received at 21/8, 8:49 p.m. DDNT 31. And in fact, in my case, Milord, at page 19, it was lost on 3:36 p.m. Mine is registered at Gwalpara PS case 165. Hers is, Milord, 166. And Milord, I was arrested in both the cases. If Your Lordship, page 24 is the charge sheet which was submitted in my case, in my FIR, page 24. And in her case, my lord, page 47. And I am behind the bar since, my lord, 15/9/2025, my lord. Will face trial, my lord. Only thing, my lord, since 15/9, I am behind bar, my lord. So, my lord, that considering the length of detention, my lord, and there is a cross affair, my lord. Both charge sheeted. This is a case of honey trapping, my lord. Nothing beyond. But I approached the, my lord, session judge, it was rejected on 25/10, my lord, that I have enclosed at page 37.
Where is the present charge sheet?
Present charge sheet, page 48, my lord, 47, annexes 8. Both cases cannot be true, my lord, otherwise. Charge sheeted in both the cases.
Is it the same IO?
Said that time, my lord. Sorry, sir. No, my lord. No, my lord. He's a government servant, otherwise, my lord, he was working in the government hospital, my lord. My lord, considering the length of detention, my lord, will kindly consider. I will appear before the trial court, my lord, as and when required, my lord.
Otherwise, the allegation is cheating and promise to marry and committing rape.
Both are adults, my lord. Yes. In fact,
So
it
how
was
many
based
days
at-
behind bars?
From 15/9, my lord. The lordship will find the forwarding at page 42, my lord, annexure 6.
So around
49.
49 days. Yes, prosecution, anything to submit?
So only translated case possible. At this stage, I prefer records, maybe, but otherwise, allegation is serious. Promise to marry and cheating and rape. Allegations.
There is no scope for absconding, your lordship. I will annex the at page 17 is my appointment order, my lord. I'm a doctor, my lord, for the National Health Mission, my lord. When I'm facing the consequence, I've been suspended, my lord, as of.
This itself appears to be a little doubtful. It has been, I think, long enough. Third learned counsel for the petitioner. Third learned edition PP. An application on the, so the allegations as reflected in the FIR. Concerns involves the petitioner having sexual intercourse with the informant upon a promise of marriage. There is also a counter FIR having been lodged by the petitioner against the informant of the instant case. Alleging among other things an attempt to involving an assault upon the petitioner with a dao. Full stop. Learned counsel for the petitioner submits that the present is nothing but a case of honey trapping. The petitioner is a government servant and there is no chance of his abscondence. And he has already spent about nearly 50 days behind bars. Full stop. Furthermore, since the charge sheet has already been submitted in both the cases, there is no necessity of his further detention. Having regard to the is directed that the petition so and so shall be released on bail of rupees 50,000 with one surety for like amount in connection with the aforesaid case to the satisfaction of the learned Elaka magistrate until petition is allowed in this. Keep the
Here also, FIR also will find at page 15. Dispute between Omen Lordship and in the FIR itself, it is stated that while she was throwing garbage, Lordship, the accused person's Lordship apprehended her and assaulted her. That is the allegation in the FIR. But fact of the case is that Lordship in the FIR also it is mentioned about 4 a.m. So the fact of the case is that on the she used to throw garbage, Lordship, in the house of other person at night, Lordship. I have the CCTV footage and a screenshot also, Lordship. Because of that, she was warned various times, Lordship, by the local people. But she did not restrain herself from doing so, Lordship. And because of that, on that day, Lordship, at night, Lordship, in the morning hour, Lordship, there was some altercation between the parties, Lordship. And for that, Lordship, the present affair was and petitioners were arrested, Lord. Lordship will see the time, Lordship, that it is it, Lordship, 3 a.m. Lordship. He used to go to the other house of other person and used to throw the garbage, Lord, inside house. All are below 7 years, Lordship, sentence, Lordship, probably custodial interrogation is not required in the present case. And they have the CCTV footage which is already handed over to the police. And they filed one bail application before the court below, Lordship, and that was rejected on the ground that they may I'm the complainant only on that ground. Page 22, last observation, your lordship, may I kindly speak. Petitioner number 3 is a student lordship, her exam is coming at December lordship. She was not present, and petitioner number 1 is her mother lord. She was there, some alteration too. She was confined by the women only.
Which of the offense is non-bailable?
Lordship, that's 74.
What is 74?
Assault or use of criminal force intent to outrage her modesty. Punishment.
The allegations is slapped and throwing the front of wearing clothes.
Admittedly, there is some altercation to play, but not with intent to outrage her modesty or all those things. Because she also used to throw that garbage, therefore she was confined, and lordship some.
Praising of modesty, but the perpetrators are all women.
All women.
Lordship.
How many days now? 1 week.
She was arrested on 1/3/25. Lordship, 1/10/20.
30-10, I think.
31/10/25, that is 4 days, 5 days.
Yes, maybe any hard done at counsel for the petitioner. Hard done it additional decision application under strength of the allegations against the present petitioners, all of whom are women, is that they got hold of the petitioner and tied her up and tore her clothes and cut her hair, and also put lime on her face, and also slapped and punched her in the face. As the petitioner was throwing household trash in the vicinity of the petitioner's premises. It is submitted that the IO has collected all the evidence, and the CCTV footage has also been handed over to the IO, and further detention of the petitioner may not be necessary. Considering the nature of the allegations and the fact that the petitioners are women, comma, it is provided that the petition will be released on bail of rupees 20,000 each with security, each of like amount, the satisfaction of the learned Talaka magistrate in connection with the affidavit. Is further provided that the petitioner shall cooperate with the investigation, shall not try to intimidate or influence the witnesses. Bail stands allowed.
Obliged, Lord.
Please, your lordship. Lordship, this is an anticipatory bail application in connection with Howley PS case number 9125 under section 137(2) of BNS, read with 351(2) of BNS, as well as section 6 and 8 of POCSO Act. Lordship, the affair is at page 8. Lordship, in the affair, there are 3 accused persons. I am currently representing number 3, Sahirul Islam. Lordship. Sir, with due respect, the informant begs to inform you that his minor daughter, namely so-and-so, is currently studying in class 9 in Kaljar Manas Academy. While she commutes to her school, accused Abdul Rahman often presented
What is the date of the FIR?
My lord. The file received at page 12, my lord, 13/10/2019, my lord.
Six boxes.
Also. No.
376, 340.
Thousand 19.
My lord.
Investigator, Lordship, entire investigation, he has not cooperated, he was not cooperating. At the charge sheet submitted.
Right, TCR can copy.
I have a next similar order, my lord. Lordship, he is ready to.
No order is similar. This is from Patasar Gusi, this is from Kasar. Different facts. Similar. You can wait for 7 years. You can wait for 7 days.
24/11.
Obliged.
Please, the lordship, 482 under section 183, 316 CD.
2011-25.
May it please your lordship. Your lordship, this is an anticipatory bail application. The FIR is on page 15. Your lordship, essentially, the FIR suggests that 2 persons, one named Aryan Chauhan and one Vijay Kumar Enghi, one person was seeking a Gaon Buda certificate. So they asked me, I am the present petitioner, Dulal Chauhan, FIR named accused number 6. So they asked me if I have any idea who the Gaon Buda is, and I connect him to such person. Then they have an agreement among themselves for the issuance of any certificate, through which I become the payee to the Gaon Buda. But I am not aware as to what the agreement is or what they have done or for what purpose it was, because I was not privy to any of those discussions. So then these persons were arrested on account of making forgery and false documents regarding government identity proofs, false Gaon Bura certificates for Aryan Chauhan, who was not a resident of Assam. So now, Your Lordship, I am apprehending arrest and I am fearful that if I am caught, I will also be put to custodial torture, as Your Lordship will see, is mentioned under Annexure 2 on page 20, that the other two accused persons were granted bail on the same account. So I am willing to comply with the investigation. I'm willing to go to the IO and submit whatever seeks information regarding this, if interim is granted. Your
But other persons were granted bail because they may be tortured.
Because they were tortured, Your Lordship. The magistrate had observed that there were injury marks on the body, and considering that he had given. So now I have greater apprehension that even though it's an economic offense, Your Lordship, and one of them being non-cognizable, that if I'm arrested, I would be put to similar treatment, Your Lord.
But after perusal of the case diary and found sufficient materials, including bail against the petitioner, sir, and sessions are rejected a prayer of.
Your Lordship,
Bail.
if we peruse the FIR, you can see, Your Lordship, that there are no
Alright,
such
22, page 22.
that I have no part in the entire transaction. The person who received the certificate was another person. The person issuing was another accused. I am merely the person who introduced these two people without any knowledge as to whatever.
Whatever, Leonard Session Judge has observed there is sufficient incriminating material against. We'll have to see the CD first.
2011, 25.
Pleasure.
Lordship, this is an absconding charge, Lordship. And this absconding charge arose in the third FIR, Lordship. Here is Lordship, the present petitioner is the sister of the husband of the complainant. And the Lordship charge sheet has been submitted against the husband under 438A, Lordship. And the present petitioner's Lordship, the sheet has been submitted against this.
Yes, wait for some time, then you can abscond and avoid, and then by the time the charge sheet is submitted, you now suddenly turn up. All along you never cooperated.
Lordship, here in this case, Lordship, earlier to affairs, Lordship, whatever allegation is made, Lordship, they did not, same allegation has not made in earlier occasion. In this affair, Lordship, it's prima facie, Lordship, it's written. Lordship, that since after marriage, she has been committed rape forcefully. But just 25 days back, Lordship, another affair, Lordship, in that affair, Lordship, she did not allege that contentions, Lordship.
So wait for some time, we don't know what is what now. It's too complicated to decide right now without seeing
Copy
the
be confirmed 2411.
scan copy.
Hello.
My lord, this 482 application is antecedent bail. Actually, I'm telling you in short manner, this is a case of mob lynching. Mob lynching, violence. One person died, and the petitioners, the petitioner, accused petitioner, is not in the scene actually.
What is his name?
Mihir
Mihir
Dev.
Dev.
Mihir Dev.
His name is there in the FIR. Is his name reflected in the FIR?
Not reflected. FIR not reflected.
FI, his name is not in FI.
FIR,
Arjan Khatun.
FIR is page 20, my lord.
Human number of human number.
Page 20.
Number 1.
Number 1, Mihir Dev, but in the FIR is not written. It's written in the FIR of Mihir Dev. And my lord, what happened actually?
Your main accused then, your number 1.
No, I'm not the main accused. My lord, I'm just coming up to the point, my lord. What happened actually, my lord? This FIR has been lodged and one Sanjeev Goswami died. Before that, we have lodged an FIR where the informant, here the informant is the main accused, Kamal Dev. And in page 36 is my FIR where we have lodged that they have attacked us. It is the counterblast of this FIR, my lord.
because he has a grudge against me. Shamal Dev, I have main accused 36. Shamal Dev is the main accused. You lost to get to 36. Wife, Shamal Dev, wife, he has lost an affair, this affair. And he is in no way victim. She is not a relative of the victim. He is a mere outsider, my lord. The affair lost by an outsider, not victim relative. First. And Shamal Dev, if you also go through the page 36, Shamal Dev wife lost an affair. That is this is the first affair, my lord. We have lost on 310. 36. Page 36, we have lost the first affair, 310. Where we have stated that they have attacked us with rod and everything, and he's a crime. And on the I just don't want to read the entire FIR. It's a big FIR. So I'm telling you in brief, my lord. So on the basis of this, the police have registered a case. And when they came to know this thing happened, they lost an FIR and put everything on blame on me. Because Shamal Dev, we have made the Shamal Dev main accused, whose wife lost an FIR. He is no way related to the accused petitioner, the victims, the killed, who was killed, he is not related. He is outside, he lost an FIR. I have stated, my lord, in I have stated in my petition, my lord, page 7, my lord, para 7, page 9. The accused begged to submit that he is in mother Srimati Usha Rani, they were simply bystander and spectator of the fight that happened between the parties. I have a name in the affair solely over the grudge that the husband of the informer Shamal Dev had over the accused and his mother Usha Dev. Additionally, it particularly mentioned here that husband of the informer Shamal Dev is a powerful and politically influenced person, and the police owing to reason based not only acting on his behalf until the date of filing an incident and district bail application. They have been accepted the mother of the accused petitioner Srimati Usha Rani Dev and Srimati Mission Dev, who has been arrested by the police. Yeah, in this case, 2 persons has been arrested. The accused, here the petitioner's mother and Mission Dev already arrested. None of the accused persons who were referred named their initial registered by civil against various persons. The husband of the informant Shamal Dev has been arrested by the police till date. Here the husband of the informant is not yet been arrested, my lord. This is the thing. When I lost an affair, he has not been arrested. Rather, on the basis of her wife affair, they have arrested my petitioner's mother and Mission Ghosh. The police is active and constantly on the lookout whereof the accused petitioner and the says present harassing his wife, Monisha Das, by constantly visiting his residence. So this is just facts, my lord. That he is not he is just simply bystander. Actually, what happened? Yes. Now, my lord, page 6, if you lordship go through page 8, para 6, I just read what petition has stated. The accused petitioner begs to submit that notwithstanding the efforts, he is absolutely innocent and not at all collected in the involved quarrel clash that took place between the parties. As a matter of fact, the accused petitioner begs to submit that he was visiting his parental house for auspicious occasion Durga Puja. During his visit, and more specifically 2/10/25, the husband of the informant Shamal Dev had an altercation argument with the mother of the accused petitioner, Srimati Usha Rani Dev. And the accused petitioner over a dispute involving alcohol being sold by one Gosti Ghosh near a puja in the evening, which was objected by the accused petitioner and his mother Usha Rani Dev. During the said altercation, the police injured the Arab the spot intervened and had to help to resolve the dispute amicably. However, the husband of the informant Shamal Dev had held a grudge against the accused petitioner and his mother Srimati Usha Rani Dev. And this is the sole reason why the accused petitioner and mother were named in the affair. As the accused person, without having any connection involved whatsoever in the fight quarrel that had happened between the parties. Actually, fight took place between the Saurabh Dev and Shamal Dev. Saurabh Dev and Shamal Dev, where the first FIR lost by Saurabh Dev against Shamal Dev. And Shamal Dev's wife, when police did not, when they have lost an FIR, police made us next that they have lost another FIR. Accidentally, through what have due to this mob lynching, that person has died. This is right, correct. But we are not, we are just simply bystander. Just we are looking because they are grudging against me to put the name in the FIR because already my wife already has a bitter relationship with the informant here and mother who was arrested. So mother was already arrested. So now police are looking after me, who I am a bystander.
So my lord, my submission is that I don't want, and I just want let me give me interim bail so that I can appear and stated my statement. I recorded my statement so that police can come to know the real facts. Otherwise, this will go on lingering. No, nobody will be arrested, and
This will go lingering means you will keep running.
No, I'm not lingering. No, I'm not running, my lord. But the thing is that nothing will come out, my lord.
My humble submission is that Lordship, one person has died, Lordship, already, and 150 section has imposed. So after appraisal of the case died, Lordship, what is his role and involvement in this case, Lordship?
Statement be recorded first. I want my
Case
record
may be
statement.
qualified this stage, Lordship.
After that, I have no objection. If you say find that I am already guilty, let the bail be rejected. Let bail rejected. Let him chance to appear before the IO.
Appraisal of the
Yes,
case,
yes,
the Lordship will consider the prayer.
He wants to surrender. And in the other affair, the police have not taken any action. This is the thing. Which we have lost, they have not taken any action, police. So we want to record, I want to record my statement because.
And on the next day, your submission will be that I have already appeared before the IO. My statement has been recorded.
If you also think that is a case that
Okay, we'll have the case there in a short date. Okay, since you have been, this is a FIR of when?
expire 2nd, 4th October.
Then 1 month you have waited. Another 7 days will not make any difference. PD.
1811.
18th. 4011, my lord.
It's from Sribhumi. It is planned, Lordship.
14.
4011. 30.
Please.
4011.
Lordship.
Yes. Today is
4011.
already 4th.
Lordship.
4011.
Lordship, I have to withdraw this case, Lordship.
The prayer of learned counsel for the petitioner, Mr.
D. Lordship.
Petition is dismissed as withdrawn.
File a press.
With liberty to file a press.
Hey, please, Your Lordship. Lordship, regular bail application, Lordship. Petitioner is behind the bar for last 118 days, Lordship. 118 days. And charge sheet has been late, Lordship. Lordship, allegation is that, Lordship, she may kindly come to page number 14. The vernacular version, Lordship. The information
It is received.
TCR is
Received.
received, Lordship. Allegation is that, Lordship, the informant was, Lordship, given a deal that if he pays, Lordship, 1,50,000, he would be given, Lordship, 8 lakh rupees in fake currency, Lordship. By the Lordship, FIR name accused person. Lordship may kindly see two accused persons are named. Wahidur Rahman and Lordship, Sabor Ali. Lordship has got it. Two accused persons are named, Lordship. Then, Lordship, these two accused persons were arrested and were released on bail by this Honorable High Court, Lordship. That Lordship will
Who are you? Two accused means what? FIR named accused is Abidur Rahman and Sabur Ali.
Wahidur Rahman and Sabor Ali.
You are?
My name is not there. I am Mohar Ali. I was arrested subsequently. Lordship may kindly see that there are total 4 accused persons that were arrested, including the FIR name accused person. 3 have been granted bail by this Honorable High Court, Lordship. Lordship will kindly see the order at page number 30. 30 is pertaining to Wahidur Rahman and Sabor Ali. They were granted bail on 48 days. Then Lordship may kindly see page number 33. This is pertaining to third accused Kurban Ali.
he was granted bail by his Honorable High Court on 53 days in custody. And the present petitioner is the only one who is left behind the bar, Lordship. And charge sheet has been laid, Lordship. And total, Lordship, 118 days in custody.
Hundred days is less than 4 months.
118 days,
Yeah.
around 4 months.
On 7/11/25 fixed protection, Lordship.
Production and copy.
And Lordship, charges are yet to be framed, Lordship, and statement
Lordship,
of.
it is a session tribal offense, Lordship. It will have to be committed to the court of
Lordship,
session.
statement of accused, Lordship, Ahidur Rahman, Lordship, kindly favor.
And he is not the even FIR name accused. Nothing was recovered from his possession.
He has been arrested on statement of co-accused.
Yes, Lord.
Any other material is there? I don't think so. Hard learned counsel for the petitioner. The hard learned additional PP. TCRS call for has been received. This is an application under so and so. Then page 35, paragraph 5. Yeah, 34, paragraph 5. The other co-accused persons, including the main accused, namely Ahidur Rahman and Sabar Ali, have already been granted bail. And orders in this respect have been annexed to the instant petition. On perusal of the TCR, it appears that all the present petitioner is not an FIR named accused, and he was arrested on the basis of the statement of co-accused. And there and no other material has been brought to notice. Considering the aforesaid facts, the aforesaid facts as well as the period of detention of 118 days, as well as the fact that the investigation has started by filing of charge sheet. Further detention of the petitioner is not considered necessary. Accordingly, the bail is allowed. 50,000 to securities like
Public.
Thank you.
Charge sheeted matter, Lordship, petitioner is behind for 124 days. Out of love, Lordship, they look to get married. And the only problem is that the victim is minor one, Lordship, the 15 years, Lordship. And the petitioner accused person is 20 years old. Now, the charges has been laid down, and Lordship will kindly see page 21 of my petition. Here a petition was filed before the additional session judge, whereby the informant of the case has appeared before the court and verbally Honorable kindly see the order on page 21, 26/9/2025. As so and so informant Subhash Sinha, the second paragraph. Second paragraph, Lordship. Informant Subhash Sinha is present and verbally offered no objection in granting bail to the accused person.
In 183 statement, she stated that out of love affair,
Hard learned counsel for the petitioner also had learned additional PP. This is an application under so and so. The text as revealed by the PCR appeared to be that the victim girl, who was a minor at the time of occurrence, had been in a love relationship with the petitioner and had eloped with him. Subsequently, she was recovered. Full stop para. By now, the charge sheet has been laid and the petitioner has been in detention for
124 days as on date.
days. Considering the nature of the allegations as well as the aforesaid facts, further detention of the petitioner is not considered necessary. 20,000 one security.
Much obliged, your lordship. Much obliged.
Lordship, after some time.
Item 20 also we have received the information as charge sheet submitted in this case. 20 of us, no? 20.
Yes, Lordship, 89 days in behind the bar, Lordship.
Is the offense?
Offense, Lordship, 61
Yeah, please, open the-
1031,
20.
Lordship,
What was the word?
ENS. It's 10 in the FIR, Lordship.
The TCR?
This year only he has to appear before the trial. Appear before the court.
Yes, appear, Lordship, 89 days, consider my detention period, I will regularly.
What is to appear? He is in detention.
Detention.
Uh-huh. What is your submission now?
Mission, Lordship, in this case, Lordship, petitioner no more.
So you
One is
are
to main accused,
you are
Lordship.
praying for bail on marriage.
Yes,
So
Lordship.
we'll have the TCR then.
Lordship, yeah.
Call for- Sorry, submitted, the charge sheet has already been submitted. Call for the scanned copy of the TCR along with PD.
Okay. 1711.
Plus.
Yes.
So accused arrested on 5/9/2025 and as of the 60 days is in custody.
We
Can you see the FIR in page number?
have not received a case there, Lordship. One minor need to review what is there, Lordship.
Hmm?
We have to receive the case there. We have not received yet.
Yeah, statutory period is
90 days.
90.
102 is there.
60.
So 1311, Lordship.
Cross FIR is also.
eh?
Cross FIR is also.
Board seat was called for, Lordship, but we have not received the board seat, Lordship. Factory 82 and 25, factory 83, 25.
There is no allegation of grievous injury or anything
Yes.
there. Then
Previous
this
injury and
50
attempt to
days
murder.
is enough, I think. Third learned counsel for the petition. Third learned TDS called for has not been received. This is an application under so and so. The allegations has reflected the FIR. Paragraph 2. From on April 9, 2025. Paragraph 2 of the bill. On perusal of the FIR, it appears that there is no allegation of having caused any of the petitioner having caused any previous injury. It is also counter FIR is at page
Rashid 18.
also brought to notice that counter FIR was lodged by the petitioner against the present informant. In the meantime, the petitioner has already spent 60 days and bars. They are considering the nature of the allegation. Further detention of the petition considered necessary accordingly. Therefore, bail is allowed. 20,000 once year.
PGM come.
Hello.
So we have not received the case diary. For data law.
All right. CD not received.
Lordship.
List again on
11.
Much obliged. Much.
Pleasure, Lordship. Lordship, for it to application, Lordship, the last occasion my learner submitted the charges submitted in this Lordship, but for our knowledge, my lord, charges submitted, but our name is not in the charge sheet. So instruction was called for, but
That instruction we have not received yet.
and copy of charge sheet along with CD not received. List again on so and so interim order passed earlier shall continue till the next date of list.
2011.
Lordship. May I please, Lordship?
Even same pair also we have not received the case diary. It is
All right, same order.
But as per my information, charge sheet late, my lord.
All right. Your own protection.
Lordship. Interview may be continued.
Lordship. We have not received the case diary.
Okay, same order.
26, 27, 28 Lordships.
Interim is there in all cases.
Yes,
The injury report was called for, let's say, along with the CD.
All right, same order. 26, 27, 28.
Lordship, I am
21, 11.
entry motor maybe. Entry motor.
Yes.
Gone.
21.
Tell him to continue DD.
Yes.
CD received.
Lord, I am appearing in item 32.
Right.
Lord, will please to find the FIR at page 9. The 31.
This is 31, 32, 33, same FIR.
Yes, I think. No, same.
Same affair, Lord.
Huh?
Same affair.
Same FIR. Okay, you are in 31.
I'm at 32, my lord.
We are having 31. Who is 31?
31. 31.
Statement of all the accused recorded.
My lord, we have duly appeared, my lord. After getting the interim, my lord.
Who are you?
My lord,
Allegation, main allegation is against the driver.
Yes, my lord, I'm not a named named person in the affair. My
What is your connection with the?
my lord, basically the
Okay.
connection is that the person who are the named accused in the affair, so they have offered the 3 seats which were allegedly stolen. So they
To
had,
you.
they had offered at a cheaper rate, so but they didn't buy it. So as 35(3) notices were received by
So you
the
have appeared already.
yes, my lord, yes. After receiving 30,
Already heard learned counsel for the petitioner. To learned additional PP. Paragraph 3 of order dated 2/9/25. Saragot Depot decision applicable. Paragraph 3 and 4 of order dated 2/9/25. It is submitted on behalf of the petitioner that he is not an FIR named accused and
yes.
he is not involved in the matter. It is also submitted that pursuant to interim protection granted by this court.
Lordship, in their statement, they stated that this Tinku Sutra, Lordship, in their statement, they have confessed that they have hijacked the truck.
They had purchased.
They have
Also-
hijacked the truck, Lordship.
Hijacked.
Yes, Lordship.
Oh,
This Tinku Shatradhar, Lordship.
oh, we are not for Tinku Satradhar.
What about you are for Matas Khan?
Yes,
What is
and Nawaz
Matas Khan?
Hussain.
No,
Huh?
Lordship, they are not. They are the businessmen, Lordship.
You are for
I'm for Matas
32,
Khan.
32, there are two persons.
Yes,
Matas Khan and
Nawaz Hussain.
yes, what is against them?
Lordship, they purchased the stolen, Lordship, till,
They purchased.
but
Appeared before the IO and it is submitted by Learned PP that the petitioners confess to their role in purchasing the aforesaid goods.
Corona.
so
So do you or do you not need custodial interrogation now?
otherwise, Lordship, they have cooperating.
Operating. It is submitted by Learned additional PP that the petitioner has cooperated with the investigation. From the above, it appears that custodial interrogation of the petitioner may not be necessary. Accordingly, the prayer for prayers bail is allowed. Pursuant the order of interim pre-arrest bail dated 02/09/2025 is hereby made absolute on the same condition. Bail petition against this.
Much obliged, my lord.
Is 31 who is appearing?
Lordship, I'm item number 31.
31. You are Tinku Sutradhar.
Tinku Sadhanidhar and Dipen Deka, Lord.
Yes, who are you? What is your
Lordship,
role?
I have appeared, Your Lordship, as
Yes,
per
what did they do?
direction, Your Lordship.
Lordship, may I read the statement, Lordship? Tinku Sutradhar,
Sadhanidhar.
সাধনীধৰ, টিংকু সাধনীধৰ। মোৰ নাম আৰু ঠিকনা ওপৰত দিয়া মতে সত্য। মোৰ ঘৰ শিৱসাগৰ জিলাৰ গৌৰী চাদন থানাৰ এলেকাৰ গাঁৱত। মোৰ মই ট্ৰাকৰ ব্যৱসায় কৰোঁ। মই কল্যাণ পাটৰ, দীপেন ডেকা, উৎপল দাস আৰু ট্ৰাক গাড়ীৰ মালিকৰ সৈতে মিলি যোৱা 14-15 তাৰিখে ৰাতি সোণপুৰত আহি এখন টিন, ঘিউ, চাহপাত আদি সামগ্ৰী থকা গাড়ী হাইজেক কৰিলোঁ আৰু শিৱসাগৰলৈ নিওঁ। শিৱসাগৰত আমি প্ৰথমে উদীপ্ত গগৈৰ দোকানৰ ওচৰত গাড়ী লৈ গৈ ৰক্ষা কৰোঁ আৰু তাৰ পৰা চুৰি কৰা সামগ্ৰীবোৰ দীপেন ডেকাৰ ঘৰলৈ নিয়া কিছু সামগ্ৰী উদীপ্ত দোকানতে নমাই দিওঁ। আমি চুৰি কৰা সামগ্ৰীবোৰ শিৱসাগৰ জিলাৰ বিভিন্ন ঠাইত বিক্ৰী কৰোঁ। মই নিজে অলপ সামগ্ৰী মোৰ ভাই সুপ্ৰতিম সাধনীকৰক বিক্ৰী কৰোঁ আৰু তাৰ বাবদে টকা পাওঁ। যি টকা মই মোৰ ষ্টেট বেংক অফ ইণ্ডিয়াৰ একাউণ্টত গুগল পে'ত জমা কৰোঁ। আমি দীপেনৰ ঘৰ আৰু উদীপ্তৰ ঘৰতে টিন, চাহপাত, গাখীৰ, ঘিউ আদি সামগ্ৰী একেলগে আনলোড কৰোঁ আৰু শিৱসাগৰত জিলাৰ বিভিন্ন ঠাইত বিক্ৰী কৰোঁ। যেনে হালৱাটিং, কালুগাঁও আৰু দক্ষিণমুখ। হালৱাটিং বিশ্বৰঞ্জনৰ ঘৰতো টিনপাতৰ কিছু সামগ্ৰী বিক্ৰীৰ বাবে নমাই দিওঁ। সকলো সামগ্ৰীৰ মুঠ মূল্য প্ৰায় 15 লাখ টকা হয়। সামগ্ৰী 15 লাখ টকাত বিক্ৰী কৰোঁ আৰু আমি সকলোৰে মাজত ভগাই লওঁ।
Your role is much more serious. Despite existence of such material, we cannot say that nothing is there. I'd learned counsel for the petition. Back in Agotudur, mother, the listeners have appeared before the IO. It appears from their own statements that they had hijacked the truck in question and sold the goods to different customers in different parts of the state for huge sums of money. Having regard to the incriminating material available against the petitioners, the prayer for pre-arrest bail is rejected. The order of interim pre-arrest bail dated 10/9/2025 is vacated. Petition stands dismissed and vacated.
Obliged, Your Lord.
What about 33?
Please, Lordship.
Lordship, I'm a businessman. I am engaged in supply of earth from Sibsagar, Nagaland to Sibsagar. I use the truck driver. So the only role I have is on 14th, the truck driver called me because he said his truck was at the highway and there's a mechanical failure. So I just helped him put inside and then I left for Nagaland. I'm not an named accused. I have cooperated with the investigation. I have appeared, given my statement. And other than that, and what my learned friend read
Yes,
out,
PP.
my name is there, Kalyan Pator.
Yes, what does Koilan Pator say?
No,
Same thing.
Lordship.
Same thing.
No, Lordship. No, Lord. মোৰ ঘৰ নাগালেণ্ডৰ সীমান্তত লাগি আছে। মই ঠিকাদাৰ হেমন্ত গগৈৰ লগত আমাৰ ওচৰত থকা নাগালেণ্ডত মাটিৰ কাম কৰোঁ। 4 লেনযুক্ত কাম নাগালেণ্ডত চলি আছে। তাতে মই চোৱা-চিতা কৰি আছোঁ। যোৱা 16 অক্টোবৰ 2025 তাৰিখে আবেলি প্ৰায় 4 বজাৰ সময়ত উৎপল দাস নামৰ এজন ল'ৰাই মোক ফোন কৰি কয় যে তেওঁৰ লগত টিন লোড হৈ থকা এখন গাড়ী আছে আৰু উক্ত টিনখিনি আনলোড কৰিব লাগিব। তেতিয়া মই হীৰকজ্যোতি হাজৰিকাৰ লগত ফোনত কথা পাতি দিওঁ। মই যিহেতু নাগালেণ্ডত ৰাস্তাত কাম কৰোঁতে উৎপল দাসৰ লগত চিনাকি হৈছিলোঁ। তাৰপিছত হীৰকজ্যোতি হাজৰিকাই আমাৰ হাল বাল্টিঙৰ বিশ্বৰঞ্জন দেৰ লগত যোগাযোগ কৰি টিন আনলোড কৰাৰ বাবে লেবাৰৰ ব্যৱস্থা কৰাই দিয়ে। আমি জানিব পৰা নাছিলোঁ যে টিনখিনি চুৰি সামগ্ৰী আছিল। পিছত শুনিব পাইছোঁ যে বিশ্বৰঞ্জন দে উৎপল দাসৰ লগত যোগাযোগ কৰি লেবাৰ লৈ গৈ আধা টিন নিজৰ ঘৰত নামাইছে আৰু বাকী আধা টিন কালু গাঁৱৰ দীপেন ডেকাৰ ঘৰত নমোৱা হৈছিল। টিনৰ বাহিৰে বেলেগ হাইজেক হোৱা গাড়ী সামগ্ৰী বিক্ৰী হৈছে বা খালী কৰা হৈছে নেকি তাৰ বিষয়ে মই একো ক'ব নোৱাৰোঁ। উৎপল দাসে মোক কেৱল টিন লোড হোৱা গাড়ী আছে বুলি কৈছিল, গতিকে গাড়ীত আন কি কি সামগ্ৰী আছে সেইটো মই নাজানো। টিনবোৰ কাক বিক্ৰী কৰিছে সেই বিষয়ে হীৰকজ্যোতি হাজৰিকা আৰু বিশ্বৰঞ্জন ডেকাই ক'ব পাৰিব। গাড়ী হাজেকৰ লগত মোৰ অংশগ্ৰহণ নাই।
Any other material?
But Lordship, the statement of Tinku Sutradhar, he stated that also Kalyan Patel, they are also associate Lordship.
Lordship, we use the truck driver. That is my only connection to the truck driver. And there is no material other than that. And after that, I left for Nagaland also because my business is in Nagaland.
No, this driver whom you hardly know, he calls you up, says that I have a truckload of tin and you come running to unload that. What is the reason?
Lordship, I use the truck driver often enough for my supply of.
Use it for your supplies, but how are you connected with the tin? Why should you be interested in coming and unloading
Lordship,
the tin?
actually, I was first told it was not, the truck was not working. Then when I went there, then they said, okay, help us get into this and unload. That's it. And then I went away because I've a word there in paragraph 9. I got to know of all of these things when I was in Nagaland and I left. I was not I just helped him and then I left.
In the statement
And I have
of,
participated. So
Lordship, in the statement of Tinku Sudhanidhar, he stated that মই কল্যাণ পাটৰ লগত মিলি ট্ৰাকখন হাইজেক কৰোঁ।
That is his confession and his statement. Lordship, we are cooperating. Our statement was recorded. Your Lordship may put more conditions, which we'll comply with. At the end of the day, my custodial, because I know the driver and helped move the truck, there's nothing more than that. A person's statement saying, I'm involved, that's it.
Okay, let's see the CD properly. Give the CD. There. If anything else is there.
CD not received.
Interim is
In time of the Lordship. Lordship, in this case, 34 Lordship, charge sheet submitted it is.
submitted that CS has already been submitted and call for the scanned copy of the TCR interim order first earlier to continue.
24/11.
The last occasion, probably the CD was received.
Yes, Mr. Botagu, CD
received, my lord.
The FIR is showing some sort of transaction, the accounts of the relative of the petitioner law. Now, what has happened in this case, the FIR has been lodged under section 316 Lordship, 316(2), 318(4), and 336(3) of the Bharatiya Nyaya Sanhita.
Now, the fact is that Lordship, I annexed one document. The Lordship kindly peruse that particular letter. It is at page number 22, annexure 3, type copy. I'm just referring to page number 23. The
First,
petition,
let us know what is the
yes, Lordship.
allegation, where is
That's
the
a
FIR?
lengthy FIR, Lordship. I'm not going to that. Only the relevant portion is at page number 20. The first information report is the paragraph number 12. On 6/8/2025, the complainant, namely Ritam Kumar Sharma of Senior Manager, North India, the Hans Foundation, lodged an FIR at this police station and stated that the accused person, namely Rajdeep Datta, who joined the organization on 15/7/2022 at Guwahati as Deputy Manager, Finance Accounts, he was appointed as head of the Finance Department for the Northeast region. The accused person, using his power of the post, he fraudulently transacted amounts of money, rupees 49 lakh something, to his family members and friends accounts, namely Anita Datta, Sangeeta Datta, who are the sister and mother of the accused, and Mamta Das, mother of the Abhishek Das, who is also an ex-employee of the Hans Foundation, by using forged documents, hence this case. So this is the basic thing, Lordship. Certain amounts were transferred to the accounts of the relatives of the petitioner. Now I'm just referring to this particular letter, Lordship. In this particular letter, he has made a mention, the petitioner, page number 23, paragraph number 5.
You have admitted at page 22.
Yes. Lordship, I'm referring to page number 23.
Yes, 22, 23. You said
Yes.
that you took the money.
Exactly, Lordship. I'm just referring to page number 23, paragraph number 5. That the above mentioned amount were transferred to these three accounts that I have mentioned in point number 3.
Yes, you were under the impression that the money was meant for needy persons and that those needy persons happen to be your mother and sister.
The wrong impression account was transferred, and I made a mention with regard to the fact that I will return the entire amount within a period of 1 month.
Very good.
1 year. So that fact is there, Lordship. Then what is the requirement of the custody interrogation?
It is for the police to determine, but
The
your
important part
role
that,
is
Lordship,
quite clear. Amount is also quite huge. Heard learned counsel for the petitioner, also heard learned additional PP.
So they appear for the informant.
Also heard Mr. So appearing for the informant. The is an application under so. The allegation against the petitioner is that he was working as deputy manager finance in the.
he was not actually working as a deputy manager. Lordship. I annexed the appointment letter. also.
That is reflected in the FIR. We are only
Page number
quoting the
31.
FIR.
Page number 31 is the appointment letter. Lordship.
But that's besides the point anyway.
Yes.
The informant company. And by misusing his position, he transferred an amount of rupees 49,00856 to his family members and friends. As it appears from annexure 3 annexed to the petition that the petitioner has also confessed to the aforesaid acts and admitted to having transferred the said amount to his family members and friends, although under the wrong impression that the money was meant for needy persons, which explanation is hardly acceptable. Given the clear implication of the petitioner in transferring such a huge amount of money. The present case cannot be considered to be a fit case for grant of pre-arrest bail. Accordingly, the prayer for pre-arrest bail stands rejected. Petition stands dismissed. Send back the seat.
Please, your lordship. So it is a pre-arrest bail application, my lord.
FIR at page 12, madam. That one, madam, in the translation, there is a little small mistake. I have typed it as two, madam. It ought to have been one, madam. Madam, I have the translation, madam. There's a little small mistake, madam.
Read the vernacular.
Vernacular, madam. Osma Zuru Nandi. Now, no. I forgot my specs, madam. It is Eknong Asami, madam. Whatever, madam, the deceased and madam, the accused number one, madam. They are madam brothers, madam. And they had a quarrel, madam. And madam, regarding land, madam. And madam, the deceased died, madam, not because of any injury or not. He died, my lord, because my lord, there were some other. My instruction is that he died a natural death, my lord. I mean, as there was a
PM report is there.
PM report also opinion regarding cause of death is kept pending till the receipt of chemical and toxicological analysis. The other part, lordship, own part and the bruise portion that not detected. That's why injury mark was there.
No injury.
No injury was there as part of report, lordship. But opinion is pending till. FSL was
That
pending.
will only be for viscera analysis.
Yes.
But the allegation is that he was hit with a baton.
Yes.
by the accused number one, my lord, not me. By the accused number one.
Anyway, hit by somebody with. So there should have been some injury.
The injury part is not here. Here, owns position and character not detected. Bruise position, size and nature not detected. Mark ligature or neck, not ligature mark detected around the neck.
But also does not say it's a natural death.
Not saying. And in the increase also, it was no injury of sound is seen lordship. But one of the
allegation is against accused number one, my lord, not me.
What is against the present one? Anything
One
is
of
there?
the-
Asif
yes.
Ahmed.
one of the statement of the 183 statement was taken of the family members of lordship. He has stated that the assault was a part of by this additional lordship made by wooden batam. That's why he fell down. One of the statement of the case also.
Well, that might be an interested witness, but in the allegation FIR, it is says the accused number one, my lord. No, there is no, accused number one.
Let us see the PM report.
Yes.
Nothing is there absolutely.
Yes.
Saying hit by batam, killing somebody.
And in the increase report also, there is no external injury of seen lordship.
That is the sense of learned concept.
I am for the informant. I have filed.
Yes, what do you have to say?
Yes.
Yes, what do you have to say?
So, your lordship, there are four candidates. However, lordship, go through the FIR itself, that he was also involved in connection with this. And moreover, your lordship, at this point of time, not be connected.
Now, what is your answer to this, the PM report? Your allegation is that beaten to death.
Yes, Lord.
Mr. Batam,
Yes, Lordship.
not a single bruise is found in the PM report
Lordship,
or in the inquest.
however, the whole family case, the FIR name accused person, all of them are in. Either,
No, you can keep on repeating they are involved, but we are asking for an answer to a query.
regarding bruise or assault, regarding that part will be the say post-mortem report. However, as per my instruction is concerned from the informant side, Your Lordship, they absolutely, all of them are absolutely involved in connection. Moreover, there is a dispute regarding Your Lordship land, that the accused person, accused number 1.
So there is reason for false application also.
No, Your Lordship. And Your Lordship, that
Your
accused number
instructions are belied by the post-mortem report. Either we believe you or we believe the post-mortem report.
More independent witnesses are there.
Yes.
Who deposed their statement before the police station.
How independent are they? What is their name?
At this point of time, can I take the information after 10 minutes?
It is all before us. Whatever you say cannot change the material available in the
Yes.
CD.
Yes.
Heard Mr. Spence, learned counsel for the petitioner and learned additional PP. Also heard Mr.
SD Royal.
Roy.
For the information.
This is an application on the so and so. The allegation is that the main accused of the case. Who is the main accused, namely?
Baharul, my lord.
Baharul.
Baharul Islam, my lord. His brothers, my lord. Both are brothers.
Baharul Islam, who is the brother of the present petitioner.
Brother of the deceased.
Huh?
Brother of the person who died, my
Brother who is the brother of the victim, assaulted the victim with a wooden batam and other deadly weapons, causing grievous injury which caused instant death to the victim. Full stop. Learned additional PP has produced the CD. Learned counsel appearing for the informant opposes the prayer for pre-arrest bail by submitting that the present petitioner is also involved in the assault upon the victim. The perusal of the post-mortem report indicates that cause of death is kept pending till receipt of FSL report pertaining to chemical analysis of viscera. Full stop. However, as far as the PM report is concerned, it appears that not a single bruise or injury was found upon the body of the deceased, which is wholly inconsistent with the allegations of assault with a batam and other deadly weapons causing grievous injury. Furthermore, the inquest reports also does not indicate any injury. Considering the above, as well as the fact that the present petitioner is not an FIR named accused.
He is an FIR named accused, my lord, but not in the not specific allegation against.
The prayer for pre-arrest bail is allowed. it is provided that the event of his arrest shall be released on bail of rupees 50,000 with one security for like the satisfaction of the arresting authority in connection with the aforesaid case. Further provided that the petitioner shall cooperate with the investigation, shall not try to intimidate the witnesses in any manner. Petition stands allowed and disposed of.
I'm
Subject
obliged,
is
madam.
the-
Much obliged.
Right, Your Honor. My lord, it's a, my lord, pure, my lord, suicide case, my lord. Petitioner wife was a, my lord, short-tempered
Copy
lady,
receipt.
my lord.
My lord, is scan TCR, my lord.
Receipt.
That is received, my lord. I have gone through that, my lord.
Notice she has received, my lord. After 12 years, my lord, as it was, my lord,
What,
suicide-
after 12 years?
it was
12 years of marriage?
No, my lord. Charge sheet given, my lord. It was a case of 2012, my lord, and it was charge sheeted in the year 2024, my lord. Initially, my lord, petitioner was interrogated by the police. When it was found, my lord, it is a pure case of suicide, my lord. Police did not give any importance to the matter, my lord. But virtually, my lord, after 12 years, my lord, it's a formal charge sheet was.
Yes, what did you, on the, what basis charge sheet has been filed? What is the material?
My lord, it is a case of, my lord, Ellis case.
My lord, allegation is dowry death, my lord. So, my lord, that is a 304B. Now,
Any statement of the victim there?
no, my lord. My lord, at that point of time, my lord, it is, my lord, C, my lord, declared died. The incident is like that, my lord. In presence of the, my lord, that is a, my lord, that is the present, my lord, accused petitioner, who is a husband of the, my lord, deceased, my lord. Took the, my lord, poison, admitted to the hospital where she is declared dead, my lord. So, this is the case, my lord. Now, my lord, here, FIR is, my lord, that is on in the year of 2012, my lord. That is, my lord, 18/8/2012. And thereafter, my lord, charge sheet submitted on, my lord, 31/1/2024, my lord. 10 numbers of PWs they examined, my lord. And my lord, still today before the committal court, cognizance taken on 29/11/2024. But my lord, I didn't notice, my lord, though my lord, incase is there, my lord, but I am not, it is not come to my notice, my lord, from there, my lord, PM report, and my lord, there is the chemical analysis.
That is also not there.
That is, I didn't get, my lord. It is not, my lord, may be there, but may not, along with the record, my lord, I didn't notice. Viscera and all this. PM report, not,
Anyway, what is the point after 13 years now?
my lord.
Again, third learned counsel for the additional PP. This is an-
Otherwise, he through his counsel might have appeared.
under so and so. PCR is called for has been received. The allegation against the petitioner is regarding abatement of suicide of his wife. Case pertains to the year 2012 and the charge sheet has been filed only in the year 2024.
24, my lord, 31/1/2024. And cognizance taken on 29/11/24.
Whereafter cognizance was taken on
29/11/2024. He otherwise through his counsel make his appearance before the court.
he appeared.
He through his counsel, my lord.
Right, my lord.
And next date is fixed on
Petitioner has also
27/11/25.
appeared through his counsel before the learned court below. Para. The having regard to the material available in the PCR and the fact that 13 long years have elapsed since the incident, and charge sheet has also been submitted. From no purpose will be served by taking the petitioner into detention in the present circumstances. Accordingly, the prayer for Pre-arrest bail is allowed. So and so shall be released on bail of rupees 50,000 with one security. Event of his arrest in connection with so and so case. To the satisfaction of the arresting authority. Click court.
Judicial Magistrate Pastas. Diploma.
It is further provided that the petition shall face the trial. Appear regularly.
CD was called for.
Can it be taken on next week, my lord? Charge sheet also submit.
That is not a matter, my lord. This person, my lord, is not my lord. I will get the bail from the trial court.
But can it be
Which
taken
item
on?
is this?
Yes, ma'am.
Item 16.
1-6.
Yes. The same issue, my lord, this his executive bail was rejected, my lord. Then on the same ground, my lord, he preferred the bail application before the trial court, my lord.
You are submitting something?
Yes, Lord, my senior is out of station today, my lord. Can it be taken on 11 or 12, my lord?
All right.
This CD may be written, my lord.
On the prayer of learned counsel appearing for respondent
Respondent number 2.
number 2, raise the matter again on
11. 12. On 11, my lord.
CD receipt be retained.
Okay.
I believe, Lordship. Matters relates to regarding Zimma of vehicle, your Lordship. In this case, as on state, I will call for report, whether the report has come or not.
Lord, report not yet received.
Any instruction whether he or not, that may be clarified. Two occasion was called for report regarding Zimma.
Regarding Zimma,
Zimma of vehicle, that you find page number 24, this is the rejection order. The two grounds were rejected. Investigation officer could not ascertain whether this present petitioner is the actual owner or not, and his vehicle is required for further investigation. These two grounds. Why
is it so difficult to ascertain ownership nowadays?
Already on that day.
Otherwise, on my lord, or through online also, my lord, ownership can be.
Anybody can do that.
Lordship, he is the registered owner, your lordships. I have enclosed registration certificate that you find page number 11. This is the RC, name of Gulab Khan. The number also there, AH01QC 759. The registered owner. In this case, your lordships, this vehicle was seized on 1/6/2025. Now almost 4 months has gone. 6 months has gone. So this vehicle is laying in campus of police station of Lakhipur. So only actual fact is, lordships, this is the registered owner and he rented this vehicle, one of his driver, that is namely Ajid Ali. Without beyond of his knowledge, the said vehicle was carrying some of petal nut of supari. In the meantime, police has been seized. Only carrying part. If he could have known about this incident, that the petitioner could have not agreed to carry those type of articles. This is the registered owner. So direction may be given the IO to release this vehicle, as because no one can claim to ownership except this petitioner, and he's already submitted all documents regarding original documents, registration, other documents before the
Concerned learned would be.
Heard learned counsel for the petitioner and learned additional PP. This revision has been preferred against an order dated
Order 18/9/2024,
passed by
passed by additional CGM Golbora.
rejecting the prayer for Jima of the petitioner's vehicle. The report was called for from the IO who has failed to submit the same on the second date as of today. It is submitted on behalf of the petitioner that he is the registered owner of the vehicle which was seized on
1/6/2025.
65 and more than 4 months have elapsed since
Yes.
then. Full stop. Para. Given the aforesaid facts, this revision is disposed of with the direction to the IO to ascertain the ownership of the vehicle and also to complete the remaining part of the investigation as far as the vehicle bearing registration number so and so
AH01 QC 0759.
within a period of
Bolero.
15 days from today. Fifteen days from submission of a certified copy of this order to the IO. And in the event it is ascertained that the petitioner is the registered owner of the vehicle, the same shall be handed over to the IO, to the petitioner upon the condition that he shall not dispose of the vehicle during the pendency of the trial or make any substantial changes to the said vehicle. And also to produce the said vehicle as and when directed by the learned trial court. Petition stands disposed of accordingly.
Biplab license.
Hello, Lordship. Lordship, I'm waiting for some instructions and some documents from the respondents. Kindly pass over the matter. Date be fixed. Thought that.
On the prayer of learned counsel for the respondent number, respondent number
All three.
on respondents and with the consent of learned counsel for the petitioner, the list the matter again on
My lord, in this case, my lord, earlier allegation, she was used to ask them, my lord, to take the status report or CT, whatever is filed.
Sir, we have not received the status report and case diary, Lordship. We have not received yet, Lordship.
Just through phone call, my lord, they may email receive, my lord. It, my lord. We are apprehending, my lord, maybe it is already charged. It is a matter of 2018, my lord. You are the my lord.
In September, we were not able to obtain the instructions.
Not
5th of September,
Yet to be.
or even before that. 3rd of
No
September.
problem, নাপাম নহয় এতিয়া কোনে ক'ম after tomorrow lordship will try to communicate
All right, on the prayer of learned
will
additional people list the matter again on 6/11 in order to enable him to obtain the necessary instructions. List again on.
May I please, your lordship? On last occasion, my lord, landed and my lord thought for time for getting instruction, my lord, whether my lord notice has been issued or not. We have not received any instruction regarding that. I see in hand. Look, like Anala. I see the instruction. 839. Notice of service. Wrongia. There is a my lord specific order, my lord, order dated 4/8/25. That my lord, my interlocutory application will be disposed of considered after receiving of the my lord record. And record, I think, has come, my lord. I had a after some time, if anything received on instruction, lordship, then communicate. After some time. After some time. If you have any instruction received from our office, lordship, we call on by happy. We don't know what to do. God bless me.
Wait, please, my lord. This is a quashing application, my lord. Here in this case, we have challenged the order passed by the learned additional and district session judge 3, whereby charge has been framed against the petitioner, my lord, under section 376, 417, and 31. Now, my lord, in this case, scanned copy of the LCR has been called for, and I think that has been received by this honorable court. And therefore, we have also been asked to take the steps upon the informant, and that also we have taken.
Who is the informant? No such person found.
My lord?
Have you given the proper address? It says no such person found.
Yes, my lord, but we have taken state. This is the only address that we have, my lord. And this is the same address that is being reflected in the format of the FIR. My.
Where is Lakhipur PS?
Lakhipur, it is in Guwahati.
Lakhipur.
I've never heard of any Lakhipur PS in Guwahati. Kamrup Metro.
Well, idea.
The Kamrup district.
House number 12, Konoklota. Where is Konoklota?
House number 12. Now, this is the address, my lord. This is the same address. If my lord may have a look at the format of the FIR.
House number 12, Konoklota, PS, Lakhipur.
Yes, my lord.
District Kamrup Metro. The only thing I have heard of is District Kamrup Metro, but none of the places they're in.
Yes, my lord.
Is there even any such place there?
So there has to be a place. My lord, may kindly come to page 17. Page 17. This is the format, my lord. There at column 6, my lord will find the name of the informant, Anandita Hazarika, and at G, my lord, this is the address.
Address
that
is
has been mentioned.
address is house number 12, Konoklota, Port, Bhangagor, PS, Bhangagor. And you have given what address? District Kamrup Metro. Permanent address is Digboi Town, PONPS, Digboi District, Tinsukia.
Then, my lord, I may be allowed to rectify my cost title.
In her 164 statement, informant address is Digboi. Presently resided Digboi in Zukia.
So you take steps on both addresses.
Will take.
Third learned counsel for the petitioner on perusal of the petition, it is found that the proper address of the respondent number 2, the address of the respondent number 2 as mentioned in the cause title does not match with the address given in the FIR format. Petitioner is directed to get the address rectified and take steps accordingly on both the addresses of the petitioner, of the informant, as reflected in the FIR format. List again after 1 week.
My lord, may I kindly fix the date in? As per the
Give it
convenience of the court, I am not pressing for anything.
Give it at
30/11, if you oblige. Correct.
Quashing petition, my lord. All the parties, both wife, family, as well as the Pettican family before the loss. They were actually, they were the major. We have also submitted the certificate. So otherwise also they are married, one child already been born, my lord. So all the parties came before lordship for the quashing of the case. Your lordship kindly see the FIR first, my lord, page 617, page 17.
Who is appearing for respondent number 2?
Respondent number.
Service result. They have it. For information. As or my lord.
Both our certificate also, your kindly see certificate, my lord. Page 18 to 21. Page 180.
What is the stage of the case?
Tax sheet submitted, next date is fixed for?
Common issue.
Common issue, madam.
And scan copy has called for that is not written. Yet na dekho earlier and my
But if that is the only ground, this is a question of fact.
They are admitting, madam, on the everything on the record. And there are so many judgment, madam, Supreme Court also given the latest one judgment is also there, madam. Even they are suppose minor, madam. Even that in that case, if they are having a happy life, as well as if they call child, in that case, madam, court is to exercise its in extraordinary power, madam. Already there, madam.
There means where?
Just your kindness, madam. Our high courts, this coordinate bench order also there, madam. It's all, there was kind of paragraph 5 first, Supreme Court order. This is decided on 28/10/25. Related.
You did not search for my orders.
Madam? Oh, they failed, madam. Maybe. I came to know your lordship also got an order. Not yet reported, but they what to have got it.
Yes, PP. What did you say?
lordship.
Because you see, at the stage of charge, they cannot obviously show that document. Court will not take into account.
Someone said it already.
Nothing more is
Unless the prosecution itself submits the certificate, that's a different thing.
prosecution also before lordship, starting with the.
All right, we'll pass orders.
Obliged.
Wait, your Lordship. Kindly one time may be given, Lordship, or take a step. Kindly one time may be given.
The prayer of learned counsel for the petitioner, 1 week's further time is granted to take steps. List again on.
Yes.
Lordship, regarding office noted 3/11/25 Lordship, regarding respondent to Lordship service report is awaited Lordship. Which party Lordship file affidavits. Lordship, we will file the reply of their objection Lordship. So Lordship kindly after 4 weeks. Lordship.
Service report on respondent number 2,
Respondent to is awaited Lordship.
not yet complete. Await list again after 4 weeks.
Take steps. They are supposed to take steps.
So we already take step Lordship, service report is awaited Lordship. As part of it noted 3/11/25.
The stay is there. Because of this stay, the proceeding cannot be taken place in the trial.
Now, if they have taken steps, then what is the difficulty now?
Lordship, we can take also, we can take a fresh step, but service report is awaited Lordship.
All right, petitioner is directed to take fresh steps by registered post ready within 3 days. Interim order passed earlier to continue till the next date of listing. List again after 4 weeks.
I'm obliged. Much.
Yeah. Yeah. Let me your Lordship. Plus, in this case, my lord, 482, and for coming for the quashing of the entire proceeding on the 2 grounds validly. First, my lord, the authority. About the authority power of attorney. Secondly, cannot fill up the lacuna. These are the 2 grounds. Now, in a complaint case, my lord, when it is filed by the company, any person who is not authorized must be backed by the Board of Resolution. That is section 291 of the Companies Act. I will place certain decisions, my lord, of our High Court as well. But in this intense case, my lord, your lordship comes to the page number 35, that is annexure 5. Lordship got it.
Just section
2. Companies Act 291. General power of the boards. I'll give the supported by the decision. Mike.
all right.
Happy.
Yes, go on.
Now your lordship will come to the page 35 of my page. It is a case of 138, my lord, by a company. I am just reading the translate copy, my.
this power of attorney is made on the 15th day of March 2002. The Lordship may note it. March 2002 by the Rajendra Kumar Gupta, son of late Ram Kumar Gupta, director of MS Gupta Hardware Private Limited, Ganeshguri, Guwahati, in the district of Kamrup, do hereby appoint Sri Madhav Lohakar, son of Sri Gopal Lohakar, marketing manager, MS Gupta Hardware, Ganeshguri, Guwahati, in the district of Kamrup, Assam, as my true attorney. Lord, kindly note this, as my true attorney and true and lawful attorney for me and in my name and on my behalf to do and execute and perform the cause of action to be done. By this power of attorney, he has filed the case, complaint case, in the name of Gupta Hardware. My lord, it is a mandatory for a company, whenever he is a legal person, whenever any person delegates his power, there must be a board of resolution. The board of resolution must be supported that yes, we have given the power of attorney to Mr. Gupta and Mr. Gupta, and in the board of resolution, it must be also mentioned that he can delegate his power to some other. But from this power of attorney, by virtue of which the complaint case was filed, there is nothing about the board of resolution, nor did not say that the board has authorized him or company has authorized him. It is says on behalf of me. That is his personal. And on this affidavit, my lord, the cognizance was taken. Now, in the cognizance, my lord, your lordship comes, page 27, annexure 3. In the cognizance, my lord, page 27. And
27.
the complaint case has been filed. The complainant has filed their evidence on affidavit along with the original documents, with the copies and original documents are returned to the complainant. The evidence on the affidavit and the photocopies of the original documents are kept with the CR. From the perusal of the same, I found the sufficient ground for proceeding on 138 of the NI Act against the accused. Issue summon to the accused. Complainant shall take the steps. But nowhere it is stated that he being satisfied with the authority by the company, by a board of resolution, that complainant is satisfied, the court magistrate is satisfied to take the cognizance. That is a very much lacuna on the part of the judicial magistrate. Because that is a settled law by S.C. Upadhyay's case, my lord, that should be, whenever there is a power of attorney, it should be reflected in the cognizance. I'll place those notes. Now, at the trial, my lord, when the trial was going on, during the trial, a specific question was given there, whether you have any power of attorney or not. He has stated categorically that I did not produce any document to show that I have been given power of attorney, a board of resolution. If your lordship comes to the evidence, your lordship record, my lord. 7/12/19. Order of the in this clear case.
Page?
My lord, not page, it record, my lord. I got photocopy.
Yes, where do you want to take us?
Yes, my lord. Well, in this order, if your lordship goes through, the court, they have filed a
Which
petition,
order?
my lord,
Which order?
dated 7/12/19.
Yes.
Well, in this order, if your lordship goes through, you'll find that they have later on, they have filed a petition under 311 to produce a power of attorney along with the board of resolution of 2018. Now he is placing the cart before the horse, because the power of attorney was given at 2002, my lord. without any board resolution. Now, when in the defense, my lord, we raise a question, the whether you have the power of attorney thoroughly approved by the board of resolution. He says, no, I don't have, but later on, he has produced that in 2018 by way of board of resolution. So that is the fill up of the lacuna. That defect cannot be, my lord. In 2018, the resolution was passed. Case was lost in 2015 by virtue of the power of attorney of 2002, and that too without any authority. Now, these are the main crux of the case. Now, my lord, I am coming. Why not? Now I am coming to the question of proposition of the law, my. Good luck. My lord, first, in which I am citing, my lord, is of our Guwahati High Court, my lord. Your lordship will come to the Your lordship will come. It is 2018 Supreme Guwahati 1237. Paragraph, my lord, 19. 2021. The decision in the Samrat Shipping Company, your lordship got it. Chopra
Yes.
was in context of the Negotiable Instrument Act, wherein dismissal of the complaint under 138 as threshold on the premise that the individual had not produced the certified copy of the resolution of the boards of directors was held to be too hasty in action. The National Small Industry Company Limited, the Supreme Court under the section referring section 291(1) of the Companies Act, which is a parameter which with the section 179 of the Companies Act has observed that a company though a legal entity can act through the boards of directors, and that the settled position is that the managing director is a prima facie in charge of and responsible for the company's premises and affairs and can be prosecuted for function of the company. And so far as the directors are concerned, they can only prosecute if they have were in charge or responsible of. Now, next part. In Dell and Kern Private Investment Limited, Supreme Court held that a company is a juristic person and it acts through the director, who are collectively referred to as a board of director, and individual director has no power to act on behalf of the company of which he is a director unless some resolutions of the boards of director company specifying the power given to him. Now, my lord, your lordship will come to the page 35 of the power of attorney. That I have shown, my lord. Where is the direction from the board, my lord? It is him, power of attorney. On me, not on behalf of the company. On this ground alone, my lord, this power of attorney has to be set aside. Next, my lord. The power of the directors are delineated in the memorandum of associations of the company, and the directors are bound to act accordingly. As agent of the company, they must act within the scope of their authority and must disclose that they are acting on behalf of the company. In the instant case, memorandum of association is not placed by the petitioner. Then, my lord, Supreme Court orders.
This was which para you were reading?
My lord, paragraph 19.
Okay.
Your lordship got it, my lord?
Yes, yes.
1920, my lord.
All right.
Okay. This is the one. Then I will place, my lord, A.C. Upadhyay's case. Yeah. A.C. Upadhyay.
Para.
My lord, para, your lordship will come to the para 17 to 19, para 20 is also there. Because this is a very important judgment my, regarding the complainant. The first question, let me start with from para 13. The first question relating to the eligibility of the power of attorney holder to be signed and file a complaint petition on behalf of the complainant, and whether the eligibility criteria prescribed under 142A of the Act is satisfied. If the complainant's petition itself is filed in the name of a payee or a holder in due course of take, answered by the larger bench as affirmed by the judgment A.C. Narayan Bachcha State of Maharashtra in 2001 with observation. Number one, my lord. As noted, though Janaki Vaishnav Bajwari related to the power of attorney holder under the CPC, but it is not concluded that in a plaint, by the power of attorney holder on behalf of the original plaintiff is maintainable, provided he has a personal knowledge of the transaction in question. It is an exception to the well-settled principal position of criminal law. It can be put in motion by anyone under the statute. One stranger to transact the question, namely the legal heirs, can also carry forward the criminal petition intimated in the criminal action in original complainant in the state of so-and-so. I'll come to the next paragraph. It is expected that such power, however, it is expected that such power of attorney holder or the legal representative should have the knowledge about the transaction in the question and able to bring on record the truth of the grievance, and otherwise no criminal justice would be achieved. Paying holder incident. The second question relating to verification of the power of attorney holder on the oath as prescribed under 200 of the Code of Civil Procedure, my lord, criminal procedure. The stand with the appellant in the criminal petition, no complaint can be filed and no cognizance of the complaint can be taken if the complaint is by the power of attorney holder, since it is against the 200, section 200 and deserve to be rejected. There is no dispute about that the complaint has to be filed by the complainant as complained under section 200. But the section does not create any embargo that attorney holder or legal cannot be empowered. From the causal reading of the section 138, 142 and 145, that paragraph read now 23, my lord. In the light of the discussion above, we are of the view that power of attorney holder may be allowed to file and dispose for the purpose of issue of process for the offense under 138, an exception to the above, when the power of attorney holder of the complainant does not have the personal knowledge that the transaction cannot be examined. However, where the power of attorney complainant is in charge of the business of the complainant alone, the personally aware of the transaction, no reason why it should not be. Nevertheless, explicit knowledge of the power of attorney about the transaction in question has to be specified. Next, in view of the above discussion, we are of the opinion the power of attorney holder cannot file the complaint in his own name. As he was the complainant, he can initiate a criminal proceeding on behalf of the principal. We also reiterated that the payee is a proprietorship concern. So that is not my concern, this is a company. Now your lordship will come to the paragraph, a case of N.C. Narayan. Next please, my lord.
Yes, I have gone through the.
Your lord, what is my lord?
Yes, I have.
That is clearly stated, my lord, that board of resolution is be there, and in the complaint petition, the cognizance, there should be a avertment that yes, I am being satisfied with the resolution and cognizance. These are absent in this. Now, my lord, I will give another decision of the lordship will please direct my lord 21.
There are 21.
21. My lord. The director as an individual director has no power to act on behalf of the company. So your lordship will refer to page 35. Act on behalf of me, not on behalf of the company. So he is an individual director. He cannot delegate the power without board resolution. That is the case before your lordship. And on this ground alone, my lord, this complaint petition has to be dismissed. And I will give another citation reason, my lord. The defect cannot be cured. Later on, when in the cross, they want to put the power of attorney with the new power of attorney and board of resolution, they have filed the case in 2015 and they have done it in 2018 and 22. That cannot be cured. My lord, the entire case is covered by this issue. 5, 7, 8, and 9. And last 10 of last, my lord, that is the Supreme Court decision of regarding the board resolution. Paragraph 17. The other decisions are there, my lord, but these are the important issues which relate to Companies Act. And in view of my commission, my lord, this complaint itself is bad in law at that insufficient, my lord, as well as after the evidence.
We'll continue then.
Yes. If anything is left, I'll give it. Anything is.
Lordship, if I can get the citations relied upon by the learned counsel meanwhile.
Yes, yes. Hold on. I'll give it.
Arrest on prisoner. Indicate. I'll put record this. To put page. Lost another day. I don't know.
The government has nothing to do. It's a private.
45. Oh, different matter.
Oh, different matter. Oh, sorry. I'll give you. Okay.
Another date, 25.
45. 10 to 11.
Yeah. Come on.
Fast to go for the day.
On 13th, Lord. On 13th of November.
This again on 13.
Always, Lord.
Made please, your lordship. Lordship, the two grounds of quashing petition is one, the validity of power of attorney. The second is while taking the cognizance, the trial court did not consider the facts of the case. Now, if I may take your lordship to page number 36 of the petition. This is the original power of attorney and page number 35 was one paragraph typed of the general power of attorney. If I may read. This power of attorney is made on so and so date in 2002 by Shri Rajendra Kumar Gupta, son of Ram Kumar Gupta, Director Gupta Hardware Private Limited, Ganeshguri, Guwahati, so and so. Do hereby appoint Shri Manab Lekar, son of so and so, Marketing Manager, Messrs Gupta Hardware Private Limited, Ganeshguri, Guwahati, as my true lawful attorney for me in my name and on behalf to do and execute and perform or cause to be done, execute and perform all or any of the following acts. Act number 1, to work, manage and supervise all the transactions relating with the marketing of the firm. The word firm is used and the only firm in this power of attorney that is mentioned is Messrs Gupta Hardware Private Limited. Coming to point number 4, which is relevant, to appear for and represent me before any court, board, government and office for filing any case, suit, written statement, etc. for collecting of dues by any party or carry out any activity of the firm.
So this power of attorney was executed by one Rajendra Kumar Gupta on behalf of the firm. Now coming to the cause title of the complaint case that was filed. Your Lordship will find it in page number 18 of the petition.
Yes.
Page number 18 of the petition. Page number 18 is the complaint petition. The case is, has your Lordship got it?
Yes.
The case is filed under the name of Gupta Hardware Private Limited. They were the payee. Under section 142 of the Negotiable Instrument Act, to take cognizance, 142 has to be satisfied, which says the complaint has to be filed in written under the name of the payee or the holder in the due course. So the complaint was filed under the name of the payee of the check. Now, through its power of attorney, come marketing manager Shri Manav Lekar. Now, your Lordship, Shri Manav Lekar is an employee of Messrs Gupta Hardware Private Limited. That means he is the agent and Gupta Hardware Private Limited is the principal. And the relationship between agent and principal is governed under Indian Contracts Act. Section 196 of Indian Contracts Act, if I may read the section. Right of person to do any act done for him without his authority. Effect of rectification.
Section
196, Indian Contract Act. Where acts are done by one person on behalf of another, but without his knowledge or authority. He may elect to rectify or to disown such act. If he rectifies them, the same effect will follow as if they had been performed with his authority. So later on, when 2018 code or resolution and power of attorney was executed, which your Lordship will find in page number 42 of this petition, they had rectified the defect. When they came to know that the power of attorney of 2002 had some error, they rectified it. So this provision will come into being. Then trial court, the second ground was the trial court failed to verify the authority under while taking the statement under section 200 of CRPC. The trial court is not obligated to hold a mini trial while taking the cognizance. They are merely obligated under section 142 to verify the complaint, to see whether the complaint is filed under the name of the payee and whether it's not required to establish the validity of all the details. The facts of the case will be seen through during the trial. So this should not be a matter of quashing. Now I may rely upon certain judgments of Honorable Supreme Court. Good. 2014-11 SCC 790 AC Narayana. I think this was relied upon by the learned counsel. Okay. AC Narayana versus State of Maharashtra.
This judgment is overruled by 15 AC Narayana, which I have given.
Paragraph number 17. No, paragraph number 26, if I may read. As
AC
noticed,
Narayanan,
AC Narayana.
2014.
Yes.
Well, if it is overruled,
Then I will go into the next citation. Bhupesh Rathore. Paragraph number 19.
yes.
If I may read.
Hmm.
In the aforesaid principle, we have to deal with the plea of the respondent that the complaint was not filed by the competent complainant as it is in the case that the loan was advanced by the company. As to what would be governing principle in respect of a corporate entity which seeks to file the complaint as dedicated can be found in the judgment of this court in Associated Cement Company Limited. If the complaint was made in the name of the company, it is necessary that a natural person represents a juristic person in the court and the court looks upon the natural person for all the practical purposes. It is the context that observations were made that the corporate body corporate is a de jure complainant while the human being is a de facto complainant to represent the form of the court proceeding. Thus, no magistrate could insist that a particular person whose statement was taken on oath alone can continue to represent the company till the end of the proceeding. Not only that, if there was initially no authority, the company can at any stage rectify the defendant by sending a competent person. Paragraph number 21. If we look into the format of the complaint, which we have extracted aforesaid, it is quite apparent that the managing director has filed the complaint on behalf of the company. There could be a format where the company's name is described first, suing to the managing director, but there cannot be a fundamental defect merely because the name of the managing director is stated first, followed by the post of the company. Now coming to the third citation, National Small Industries Corporation. Paragraph number 16. If I may read. Section 142 only requires that the complaint should be in the name of the payee where the complainant is a company. Who will represent the company and how the company will be represented in such proceeding is not governed by the court, but the relevant law relating to companies. Section 200 of the code mandatory requires an examination of the complainant, and where the complainant is a corporal body and evidently only an employee or a representative can be examined on its behalf. As a result, the company becomes a de jure complainant, and the employee or any other representing in a criminal proceeding becomes a de facto complainant. Citation number 4. Paragraph number 25.
Yes. Go on.
Paragraph number 25, last 5 lines of the paragraph. If at all there is any serious dispute with regards to the person prosecuting the complaint not being authorized, or if it is to be demonstrated that the person who filed the complaint has no knowledge of the transaction and as such the person could not have instituted and prosecuted the complaint, it would be open for the accused to dispute the position and establish the same during the course of the trial, not during a quashing proceeding. As noted at Samarat Shipping Company, a dismissal of a complaint at the threshold by the magistrate on the question of authorization would not be justified. Similarly, we are of the view that in such circumstances, entertaining a petition under Section 482 to squash the order taking cognizance by the magistrate would be unjustified, where the issue of proper authorization and knowledge can only be an virtue for trial.
Yes.
So whether the authorization was valid or not, it's a matter of trial. Question of facts. The 5th citation.
But wasn't it during the trial that this impugned order was passed, allowing them to be represented by introducing the new evidence?
Yes, the magistrate had allowed them to file a new petition, and the person who had initially filed the complaint petition was only given the authority in
But if
2008.
he doesn't challenge it now,
He can challenge it before the trial court.
then the question will arise.
Yes, I have already challenged them in the cross. Because your lordship, if I'm not wrong, my lord, your lordship comes to the page 6.
Okay, you'll
Yes,
in your reply we'll see. Let her finish first.
5th citation, paragraph number 5, Standard Chartered Bank. Law in this regard is now settled. Anybody can set a criminal law in motion by filing a complaint instituting an offense. For an offense under NI Act, only criteria prescribed by Section 142 is that it must be instituted by the payee or the holder in the due course. The fact that the complaint lodged by the manager or any other employee who had not been authorized by the board of directors to sign and file the complaint cannot be a ground for quashing the complaint. Contrary, so-and-so, the last paragraph number 11 in this, I will read. This court has so far gone back in the case of so-and-so held that it was clear that anybody can set a criminal law in motion by filing a complaint of facts constituting offence before the magistrate entitled to take cognizance. It is held that no court can decline to take cognizance on a sole ground that the complainant was not competent to file the complaint. It has held that if any special statute prescribes offences and makes any special provision for taking cognizance of such offence under the statute, then the complainant requesting the magistrate to take cognizance of an offence must satisfy the eligibility criteria prescribed by the statute. In the present case, the only eligibility criteria prescribed is Section 142, is that the complaint must be by the payee or the holder in due course. This criteria is satisfied by the complainant is in the name and on behalf of the appellate company. In our case also, it is in the name of the in the name of the company. Now the sixth judgment, paragraph number 12 and 13.
Yes, okay. I have said it can be filed subsequently.
Yes. And judgment number 7, paragraph number 3.
That has also already been referred to in Standard Chartered case.
Yes. So this says it can be later on rectified. It's a technical error, not a curable one, not an incurable one.
Yes.
Union Bank of India, paragraph number 10 and 11. It cannot be disputed that the company, like the appellant, can sue and be sued in its own name under Order 6, Rule 12 of Code of Civil Procedure. A pleading is required to be signed by a party and its pleader, if any. As a company is a juristic entity, it is obvious that some person has to sign the pleadings on behalf of the company. Paragraph number 11, the court below have held that Shri so-and-so must have been empowered to sign the plaint on behalf of the appellant. In the alternate, it would have been legitimate to hold that in the manner in which the suit was conducted shows that the appellate bank must have rectified the action of so-and-so in signing the plaint. If for any reason whatsoever the court below were still unable to come to this conclusion, then either of the appellate court ought to have exercised its jurisdiction under Order 41, Rule 27 of the Code of Civil Procedure, and should have directed the proper power of attorney to be produced, or they could have ordered Shri so-and-so or any other competent person to be examined as a witness in order to prove rectification or the authority. Paragraph number 13, the court below having come to a conclusion that money have been taken by respondent number 1 and that respondent number 2 and the husband of respondent number 3 had stood as guarantor. The last line, the suit did not suffer from any jurisdiction.
You're reading Bhajanlal?
No, I'm reading United Bank of India.
Okay. Yes.
The last line of paragraph number 12, the suit did not suffer from any jurisdictional infirmity, and the only defect that was alleged on behalf of the respondent was one which was curable. So, Lordship, my argument is that the action of the agent, that is Manav Blecker, who was representing the company at time of filing the complaint, was later on rectified by the power of attorney dated 2018. In the power of attorney of 2002 also, the director who had given the power had time and again said that the power is given to act on behalf of the company. The acts had to be done for the company. And being agent and principal relationship, Section 196 says that later rectification is valid. And the judgments of Honorable Supreme Court also says that it is a curable defect. The company can later on rectify the same. So the quashing proceedings should not be allowed. And they can bring up this matter during the trial, during taking the cross of PW1, or calling other witnesses to challenge the authenticity of the power of attorney.
Your Lordship, my learned friend submitted the trial. Yes, in the trial, you have raised this question. Your Lordship will come to the case of my case 6 of the paragraph 6. Your Lordship got it, my lord.
Yes.
That C. Madhav Block or PW1 was cross-examined by the counsel of the accused, wherein PW1 stated, Gupta Hardware Company is a company. I have been working in the aforesaid company since 15 years. The Rajesh Gupta, Pradeep Gupta, Shakuntala Devi, Sapna Devi, and Rishi were all its directors. In the year 2002, your Lordship may note that probably there were 5 directors in the company. The 2 directors are said by me as above are the director after after 2002 and 2009. We have board resolution before execution of we have the board resolution before the execution of the exhibit 1. That is the power of attorney, my lord, which I have stated, given by Rajendra Gupta, in my favor, but I have not submitted the board resolution before the court. And that is the crux of the case, my lord. Because Apex Court has said an individual director cannot delegate the power to another person without the approval of the board of resolution. That is a mandatory. Number of decisions of the Supreme Court have cited, Dal Carneys and all. Now then come, the director who became the director after 2002 has given the power of attorney to the board decision, but I have not submitted the same before the court. If the power of attorney has been given, resolution has been given in 2002, then why to give the new power of attorney in 2018? He could have produced that 2002 resolution. Why?
Yes.
Why he has to give in the 2018 the new power of board of resolution? At that time he could have given. Even in the cross also, he could have said, yes, I have failed to give the 2002. Here is the resolution. Why the new one, 2018?
With all due respect, Lordship. Right.
Why in 2018, my lord? When the case was filed in 15 without any authority? The section 291 of the Companies Act given this case 2014 Superior Law. The last still clear, my lord. Last page, my lord. Section 291 of the Companies Act 1956, it embodied the principle that subject to the specific exception mentioned, the directors of the company and its governing body are entitled to exercise all the power of the company. In the instant case in hand, it is noticed that the Lower Appellate Court, that article of association of the company, did confirm the power on the director to sue or defend any proceeding on behalf of the company. A delegation of such power can only by the resolution of board of the directors. Hence, a letter of authorization or a power of attorney executed by the chairman or other officer of the company without delegation of the power to institute such proceeding having emanated from the boards of directors would invalid any proceeding before without necessary authority. Now it is crystal clear, my lord. There must be, because when the
Here also it says it can be cured at a subsequent stage.
can be cured. But here is the case, my lord. When the specific question was asked in the cross, the 2002 resolution, have you produced? He is producing the 18. When the cognizance was taken in 2015. At the time of, because Dal Carneys case, in the AC Ukadda, you will find, your
No,
lordship,
suppose supposing there was a resolution of 2002. Is the company prohibited from passing a fresh resolution in 2018?
my lord, new director has come, my lord.
That is why the
Whatever.
In 2002, there were 4 directors. When the case was installed. In 2018, this is the new director has come.
No, number or the
Yes, my
name
lord.
doesn't matter. It is the board that has to authorize.
You will see, go through the AC Narayan's case. I mean, it is complete clear. Because at the time of filing the complaint, resolution is a must. Because Supreme Court time and again says, individual director cannot delegate his power without the board of resolution. And that has not submitted at the time of.
In the judgment, this one
Yes.
that you have cited of the
Yes, my lord.
Karnataka High Court, here it says this lack of authority could have been supplied even before the appellate court.
Yes.
When the issue arose for consideration. So
because the resolution are earlier, not afterwards. After taking
it
the
does not say anything like that.
Yes, my lord.
Nothing in that regard, nothing is said in the judgment.
Yes, it is said it, my lord. The court has constantly held for any person to present the evidence in the court of law on behalf of the company ought to have authorized under the article of association. Where is that authority, my lord? I am challenging the authority of this person, my lord. Madhav Kumar Lohapal. By separate resolution. In result, the proceeding are held to be vitiated for want of authority to prosecute the complaint on behalf of company by power. Let it is more clear, your lordship goes to the Apex Court decision 2004 State Bank of Tanjore purchase Kingston Computer. The Apex Court. That is clearly stated, and if resolution, without resolution, nothing will go
Where?
forward.
Which one you have supplied already?
Yes, your lordship. Your lordship will go to this Supreme Court of India, my lord, 2011-10682. State Bank of Tanjore purchase Kingston Computer.
Yes, yes.
Your lordship, the last
That we
one-
have gone through already.
Yes. This is still clear, my lord. I'm not disputing that he has no authority, but he has to submit the board of resolution to satisfy. After cross, he is putting the new resolution. Whether that is valid in the eye of law. At that time,
Travancore was which paragraph?
your lordship, paragraph 17.
17.
Yes.
There is no 17. Ends at 15.
Travancore. State Bank of India versus Travancore.
No, I have got State Bank of Travancore. You are referring to State Bank of India.
No. State Bank of Travancore. Purchase Kingston Computer.
It's a 4-page judgment and it ends at paragraph 15.
15 is there.
Last is 15 as far as I can see.
Then it will be 14, my lord. According that is your lordship. Take this.
In our view.
Yes.
Huh?
In our view,
Yes, that's
the
14.
judgment under challenge is liable to be set aside because the respondent had not produced any evidence to prove that Sri Ashok Kumar Shukla was appointed as director of company and the resolution was passed by the board of directors to file the suit against the appellant and authorize Sri Ashok Kumar Shukla to do so. The letter of authority issued by the Rajkumar Shukla, who described himself as chief executive officer, was nothing but a scrap of paper because the resolution was passed by the board of directors, delegate power to Rajkumar Shukla to authorize another person to file the suit on behalf. Here is, my lord, the person Rajendra Kumar Gupta, by power of attorney, he said on behalf of me, not on behalf of the company. Your lordship will see the authority letter. The lordship will see the authority letter first.
No, once the subsequent resolution,
Yes.
subsequent or prior, whatever, is introduced,
Yes.
that earlier power of attorney is not of much significance. Because if the board says he is authorized,
Again, but the question is. that
the
will be-
question is whether
But
the only question according to your submissions is whether that resolution of the board should be a pre-existing one or whether it can be subsequently
This is
given.
the pre-existing one.
Yes.
Because SU Upaidhyay's case clearly stated that no complaint should be taken without examining the power of attorney and the board. SU Upaidhyay's case is there, 2015.
So your in other words, your submission is that the decision cited by the other side, where it has been said that it's a curable defect, only means that if it is already in existence, you can introduce it later
Yes.
if you had not
Yes.
done it before.
But not subsequently. And my lord, the decision which my learned friend has submitted, mostly is for corporation.
Companies, private
Companies also
limited.
Companies also
Yes.
under submitted the decision, mostly your official MMT and all these are national small industry. These are corporation, public sector. The public sector officer, they are the public servant. They can reduce the evidence without any authority also. Only the need is that he has been authorized.
No, the judgment does not say that he can do without authority. It says that it can be
My lord,
ratified.
it's just clearly stated that.
What? That without authority?
No. He's a public servant can. That is in the issue of the public servant. The national small industry is a corporation which is deemed to be a public, any person is a public servant, that is. It's a government of India undertaking.
Yes.
There also will be needed a resolution that will entrust the managing director to authorize some other person.
But have these citations distinguished between private and public companies?
My lord, that is why Dalpani's case is there. I have given that. California Supreme Court. In the SC, but then in other cases also. So my simple submission that even if they have the power of resolution before filing this case, they ought to have produced that. They have not produced that, and they are producing the new power of resolution. Thereby, it means they have misled the court. Because he said that we have the power of resolution. That has not been produced. They are subsequently they are producing it.
It was produced in 2018 and it is dated what?
2018.
Okay.
After the cross, my lord. After the evidence is closed. Not before the cross, my lord. Your lordship will note that. After the cross, when you cross him, then later on he subsequently produced this by a way of petition. And we have given objection to that, which the learned court has allowed. We should not be under the 311, my lord, to fill up the lacuna. Just to fill up the lacuna, my lord, if the documents of 2002 was not given, then if it has been taken, we can accept it. But giving a fresh document to rebut my evidence is not allowed in under 311.
Yes, yes.
This is my submission.
If I may, Lordship. Lordship, first ground taken is the power of attorney at the submission of board resolution in 2018. That doesn't mean that the board resolution was not there prior to 2002. The later on board resolution was submitted because two more directors came in the subsequent to passing of board resolution 2002. That is why fresh power of attorney was submitted before this honorable court, before the trial court.
That is her argument itself says so, that at the time of taking cognizance cross-examination, there was no board of power.
I said there was resolution, but later on, due to the addition of two more directors, fresh document was executed. After submit.
After crossing, my lord, they have submitted. That will be your lordship will note. After cross of the evidence.
There is no barred in law that says after cross-examination, we cannot annex any document, we cannot submit. If the learned trial court has permitted us to submit fresh evidence, we can submit fresh evidence. And after filing of an application for giving us permission for filing fresh evidence, we have filed fresh evidence. They should have challenged that order where the learned trial court has allowed us to file fresh evidence. Quashing proceeding is not correct. And this is a matter of fact whether such board resolution existed prior to filing or not. And none of the judgments which I had relied upon explicitly says that the said board resolution should be prior to filing of the case. It says even if initially, Samat Shipping even says that even if initially there was no authorization, it can be later on rectified. The word initially means at time of filing, if the representative was not duly authorized, it can be rectified. That means that rectification would follow after the filing of the complaint, not prior to filing of the complaint. When the order of Honorable Supreme Court, we rely upon every word matters. The word is initial authority. If there is not an initial authorization, it can be cured later on. And later on, when we came to know, we submitted the fresh power of attorney. There is no law that barred us from executing a fresh board resolution, from submitting a fresh evidence. We had followed due process. We had filed an application for filing of fresh evidence. The application was allowed. Subsequent to that, we had filed our evidence. And this should be a matter of trial, whether such a document exists or not. It should not be a matter of quashing. Because for quashing, two things matters. One is the court went beyond its power. The other is abuse of justice. In this case, nothing was there. They have not denied that they didn't owe us money. The only is the technical ground, which is a curable one. laid down by various Supreme Court judges.
All right, yes, that's right. What she has submitted, I just want. Your lordship goes through the AC Narayan case, it will be.
We'll go through all cases. Why
Yes,
only case in
yes. Your lordship will clear.
And nowhere it is written, Lordship, that a corporation can later on rectify, but a company cannot rectify. The Company Act says so, agent principal contract act says so, that we can rectify the defect.
Yes.
I would highly depend on section 196 of the Contract Act.
Judgment reserved.
Yes, CA.
No complies.
Timing orders. Some information was sought, I think. Yes, any information?
We have not received any information regarding the service of notice, Lordship. Some misplacement was there, Lordship. We have not, from our office, Lordship, it was not communicated. We have not missed the file. Service look very expensive. That was why nay.
PCR is also not received, I think.
PCR also not received.
PCR has been received.
Received.
And there is an order also, Court 8 and 25. Para 8.
The third learned counsel for the petitioner, learned additional PP submits that. But the notice has not been sent.
Not been sent from our office, Lordship.
That due to some mistake, the notice hasn't on respondent number 2 has not been sent. Hence, list the matter again on. How long will you need?
7 days, Lordship. Next week, it Start in 11, Lordship. Done. Correct, I didn't. What?
Yeah, please, your lordship. Lordship, my senior is on legs before the division bench in court number 6, Lordship.
He said he was going to finish it today. I just met him at lunchtime.
Yes, he will do the hearing, but it's on legs for the division bench in court number 6, Lordship.
We are at the end of the list.
Matter is going on 10.
Yes, next item. Next. Any item left?
Wait.
Yes.
Before going to the main issue case, I would like to point out your lordship two things. Filing of the division, respondent filing of objection. Kindly lordship may peruse the page 64 of the objection.
Yes, so what happened? We
Yes.
filed an objection.
Yeah,
So,
they have filed one objection, lordship, to bring on record one petition and other, and along with some orders of the Thanet trial court, whereby it was alleged that petitioner before your lordship has suppressed certain things while preferring the revision. And to that extent, the petitioner has also filed a reply, wherein it clarified that at the time of filing of the petition, that leave was already taken because the certified copies could be obtained at that point of time, so it will be an act. So my respectful assumption is there is a disputed facts, some disputes regarding the facts of regarding the submission of the petition and legal trial court lawsuit.
So my humble submission, Lordship, before hearing the matter, the PCR may be required, Lordship. Because
TCR, without TCR, this matter is listed for hearing.
yes, Lordship. TCR was
Lordship,
not called for on earlier occasion, Lordship.
To mention here that they were challenging the limitation that was not granted to them. Limitation, for that reason, they have in the main criminal revision petition, they have not annexed the miscase petition that was filed before the additional district judge, which I have filed it additionally. So the record is not, I think the record is not necessary because I have in my objection petition, which I have filed, that is in page number 62, I have filed, which my learned friend has failed to file, I have filed the certified copy of the miscase, which they are complaining about,
Lordship,
and the order copies, certified copies of the order. The
You will
seeking
find that,
revision
that-
regarding that matter only, regarding the delay in filing the delay condonation petition, which I have filed.
Page 71 of my page 71, the petition which the delay condonation which was preferred by the preferring the appeal. Page 71 Lord, of the objection law. The evident opposition filed by the respondent.
71 is an order.
In my petition which they have served on me, it is a petition, Lordship.
Punish the orders also, your lordship, if my learned friend.
There are two numbers here.
Sorry, Lordship.
There's a numbering.
Maybe numbering mistake. also.
Your Honor, there is
And
a numbering mistake.
While annexing the petition, they have not annexed the medical certificate which I have submitted from a trial court. And that medical certificate I have annexed in my reply. So, Lordship, whether I have submitted that medical certificate or not, it is up to the is in the trial court record, Lordship.
Your
It is to be
lordship,
paid.
I would beg to mention.
All right, let's have the record. What is the difficulty?
Yes, your lordship, just I would like to mention here one thing, that in the petition, miscase petition, they have exclusively mentioned that, may I read, please, your lordship may allow me.
Whatever you do, I will not remember anything if we call for the records.
Yes, your Honor,
You can make your submission then. What is the point of submitting now?
yes, your Honor, the entire record is actually here only. And
Lordship, the
they
delay
are
of
just.
It appears that the PCR would be required for final disposal of the matter. Let's call for the scanned copy of the PCR. List again on, give a date.
Your lordship, date may be fixed.
Yes, give a date.
Yes.
if,
Oblige, your lordship.
it's
Is this IA?
Lordship.
What is this IA?
The IA we have, and we have got a relief. Except
It is disposed of.
it should be disposed of.
No, is it disposed of? Oh.
And that is not disposable, Lordship. It may be hard together along with the main.
It is hard and
You are saying we have got the relief. What does that mean?
it so happens that the order was passed and we got the relief of entering the house. Now we are residing there for the last 1 year. Thereafter, we have been coming to the court to dispose of the IA and also dispose of the criminal revision petition.
So today the matter is for the IA only.
The IA may be disposed of because the IA, we have got the order dated 11/9/2024. Thereafter, after 2 months, around 19,
It is submitted on behalf of learned, by learned counsel for the,
yes.
Your
for the
counsel for?
respondent, For the respondent.
for the respondent that the instant that the relief claimed in the instant IA has already been received by the respondent.
Only one more direction we need, that is for the electricity bill, the electricity to be provided in the bathroom area and water supply. That is what he's
That is
withholding.
what,
and
that
not-
means the relief is not there.
The relief we have.
Prayer is not there, Lord. But the prayer is not there when the order was passed also.
That
No, when you submit that, you have got the relief.
we have got the
That is
relief.
why we are proceeding to pass the order, and in the course of the order, you are introducing new things now.
That is after the.
There is
situation
no
that
prayer,
is-
we are not passing any such order.
All
We'll
right.
file
so
fresh application if
the
necessary.
disposal of the IA. We'll go for the disposal of.
In view of the above, the ayes stands
Lordship,
disposed of.
Lordship, I have a submission.
Yes.
Actually, paragraph 11 of the order dated 11/9.
How are you agreed by the disposal of the IA?
Lordship, because why it is because I'll read out.
We are not passing any fresh order in the IA. We are simply saying it's disposed of because petitioner says he got the relief.
Lordship.
That is all. How are you agreed by that?
No, Lordship, because that is because why? I'll read out, Lordship. Paragraph 11 of the order dated 11/9/2024. Considering the submission of learned counsel for the parties and in view of the beneficial legislation as enumerated in the DV Act and the law propounded by the Honorable Supreme Court, Prabhat Tyagi Supra, the interim protection is granted to the applicant by allowing her to stay in the said household along with her child until further order. Till then, the order dated 11/12/2023 shall be kept in abeyance. Lordship, order dated 11/12/23, the proceedings were stayed. Just because this is kept in abeyance, the order that previous order of staying, that is not being wiped out. It's still kept in abeyance. So what my prayer would be to hear the matter, the criminal revision petition 525 along with this IA Lordship and dispose of the entire matter.
I have
together, Lordship.
objection to that. I have objection to this because on several occasions, this IA being standing there, the matter keeps coming for orders rather than for final hearing. So therefore, we pray for Lordship to dispose of the IA with the previous order. So the proceedings in the trial court can also go on. The trial can.
That should have been your first submission. You started with the submission that you have got the relief. Now you are turning around.
We apologize for being a bit hasty about that. The first submission should have been about the trial court being able to conduct the trial. This is only a residence order for the child and the mother.
Yes, the interim order is against you. So what is your submission? Why should we vacate it?
No, interim order, Lordship, Lordship, the interim order was passed on the motion date. That the proceedings has stayed, Lordship.
So you submit why we should vacate it.
That should not be vacated, Lordship. That is my, the petition is all about, Lordship. The interim order should not be vacated. Here in the
Interim order is in her favor, is it not?
Yes, Lordship,
It
yes.
should not be vacated according to you.
Yes, Your Honor. And that is not vacated, in fact. It is given for a
If
period.
it should
of
not
time.
be vacated, we make it absolute.
We make
Matter
it
ends there.
That's all we are praying for.
No, making it absolute means, Lordship, because we had a stay order early. And the second interim order, after filing of the IA, Lordship,
We are on 11/9/24 order.
Yes,
Cadet order residence
that is not
has been
vacated,
granted.
that is not vacated, Lordship. That is kept in abeyance only.
Which is kept in abeyance.
He's talking about the trial in the trial court being kept in abeyance.
It seems you have not gone through the brief.
I have
This order may be made absolute and the IA may be disposed. Lordship, only then the case will proceed and reach its final destination.
The earlier stay order is not vacated, Lordship. That has been kept in abeyance only, Lordship.
The order passed by which court?
This will not be court, Lordship.
Huh?
This will not be court.
Passed in the IA or in the main appeal?
In the main appeal, Lordship. Main criminal petition, revision petition. On the motion itself, Lordship.
No, that is what we are submitting. It's not, it so happens that after hearing the IA, if an order has been passed, the IA may be disposed of. And the case will proceed with the main petition.
Yes, so what is your submission on the IA?
IA's lordship, it may not be disposed of as of now. That is the captain abeyance, and that is why lordship, because allowing the aggrieved party along with the child in the matrimonial home, that is what is being challenged in the criminal revision petition, lordship. And when the IA
So the issue involved in the IA is substantially the same as involved in the main petition, is it?
Yes, lordship, that is what. So that is why my prayer is that both the matters should be heard together, IA and the criminal petition.
Okay, we'll hear.
It's coming up all the time and he can make his submissions today. Whatever he wants to say, because it will be listed in the same manner all the time. If this is not disposed of.
Are you prepared to argue today?
Lordship.
Okay. Today? Yes.
The impugned order of Dame Epsi lordship, that is at page 97. I'll read out, lordship.
Page?
Page 97, lordship.
Yes.
The aggrieved person is present, the respondent is absent with step, and the white petition number 1747 2023 has cited the ground of official work for being absent today. The aggrieved person white petition number 174623 has prayed for another date for submission of her affidavit of disclosure of assets and liabilities. The aggrieved party white petition number 174523 has prayed for interim residence order and interim protection order against the respondent, service copy of which has been received by the respondent. Heard both sides on petition number 174520. The aggrieved person submitted that at present she has no place of dwelling in Guwahati for herself and for her minor son. Peruse the contents of the main petition filed by the aggrieved as well as the DIR, which prima facie satisfies this code that domestic violence has indeed taken place or is likely to take place. This is to be reiterated, Lord. So I'd like to reiterate this one, that the domestic violence has indeed taken place and is likely to take place with the aggrieved. Considering the utmost urgency of the circumstances for grant of interim residence order as regards said household, this code hereby directs the respondent to allow the aggrieved person to continue her stay in the said household at Guwahati until further orders. The respondent is also directed not to exclude the aggrieved person and her minor son from the said house.
Yes, all right.
Lordship. Yes. So this was the order of residence order, lordship. Then lordship, I preferred one appeal against this impugned order, and before the additional session judge, lordship, Kamrup Metro, and I'd like to take you to page number 138, paragraph 17, lordship, of the impugned judgment of the appeal.
Page?
Page, lordship, 138, lordship.
138.
130. It's paragraph 17, lordship.
Yes.
From the perusal of the contents of the written objection submitted by the appellant opposite party, it appears that he himself stated that he was upset for her not staying in her matrimonial home even during pregnancy, for which he admits that he could not take care of her with the child in her home since the embryonic stage. He could not much help
the aggrieved person during her pregnancy, as he has ailing parents and physically challenged brother at home. Paragraph 18, the conduct on the part of the appellant as disclosed in the petition of the respondent petitioner is found fortified from the written objection submitted by the appellant opposite party to the extent that the appellant did not take care of the respondent petitioner during her pregnancy, which obviously amounts to domestic violence. Now I'll come to paragraph 20, Lordship. According to customs of our society, after marriage, bride goes to the residence of the bridegroom, that is her matrimonial home, and it is her right to live there. And pendency of the divorce case cannot be a ground to disallow to a wife to live in her matrimonial home. I'll explain this one. Pendency of divorce case cannot be a ground to disallow to wife to live in her matrimonial home. In the one hand. On the other hand, the minor son of the aggrieved is suffering from illness and he needs medical treatment to be provided at Guwahati. So, ordering the residence order in favor of the respondent under the given circumstances is nothing but expression of her legal right by a competent court of law. It is also interesting to note that the appellant in his long presentation of the appeal put emphasis that in spite of his request, the respondent did not stay at her matrimonial home. As such, he even accompanied his brother, went to the rented house of the respondent to bring back the matrimonial home. But she refused. As such, he lost FIR against the respondent, and subsequently, he even filed divorce case against the respondent mainly on the ground that respondent is not staying at her matrimonial home. But when the learned court below has passed the impugned order allowing the petitioner to stay at her matrimonial home, the order is challenged, which amounts to double standard adopted by the appellant. I don't agree with this also, Lordship. The order is which amounts to double standard. I'll explain this, Lordship. Upon perusal of the impugned order, it appears that the learned trial court below considered the contents of the main petition filed by the aggrieved as well as the denier, which prima facie satisfied that the domestic violence indeed taken place or is likely to take place with the aggrieved. And he, in the next case, Lordship, at paragraph 7, he affirmed the earlier order, impugned order of the JMAPs. Lordship, here's the difference between staying in the matrimonial home as a matter of right and for the child, Lordship. I'll come to Lordship, there's a restitution case filed. Because before I take up the restitution case, I'll take the Lordship with the timeline of the cases filed, dates and events, Lordship, at page 16 of my petition, Lordship, starting at page 16.
Yes.
Dates and events, Lordship. My grounds. 11/3/2015, date of marriage, Lordship, that is an admitted fact. Child born out of the wedlock on 21/11/2016, that is being admitted. Now, Lordship, date of separation, 16/9/2017, date of separation, paragraph 8, pages 7 to 8 of the domestic violence main application, that is being annexed there with Lordship. Then 9/9/2017, revision petitioner went to Bangarabari to take back the respondent number 2 wife to her matrimonial home. The respondent wife refused to come back and assaulted the revision petitioner husband with guns. 10/9/2017, FIR lodged by the revision petitioner against the respondent number 2 wife under section so and so of the IPC. 8/6/2018, revision petitioner husband filed divorce case. Void abscess civil case number so and so. 12/7/2019, wife filed a case for maintenance under section 125. That is almost a year after filing of the divorce case, Lords. 4/9/2020, again 1 year later, Lordship, after filing of the divorce case, it is 2 years later, the respondent were filed restitution case, but with the same allegation which has leveled her in the case for domestic violence. Domestic violence case was preferred after 2 years of filing the case for divorce. It's not restitution, it's for divorce. And after 5 years after separation between the parties. 12/11/2020, wife
No,
claims.
what is, which one? 4/9/20, she filed restitution case.
That is, there is more than, in fact, 2 years after the filing of the divorce case, Lords. She filed the restitution.
Divorce case was filed by you.
Yes.
4/9 is the restitution case. Then
Yes, Lordship.
it was 2 years after the
Divorce case was filed.
The-
1 year after the divorce case was filed, she files a maintenance case under section 120.
so this restitution should read as divorce.
Yes,
Page
Lord.
18.
Yes, Lordship. Lordship.
Yes.
Then Lordship, 12/11/2020, the wife claims in her main DV application that on these 2 dates after filing the divorce case and after filing the restitution case, she tried to visit her matrimonial home, but the revision petitioner did not allow her to enter the matrimonial house. The respondent number 2 wife, after filing the divorce case, and after more than 3 years of separation, almost 5 years of separation, felt that she should visit the matrimonial home. That the respondent number 2 tried to visit her matrimonial home on these 2 dates are false claims. The revision petitioner denies that the respondent number 2 tried to visit her matrimonial home, and at the same time, he begs to state that if she actually would have tried to visit her matrimonial home, he would not have allowed her to enter the matrimonial home because the revision petitioner does not want to lose his grounds of defense in his divorce case, Lords. 21/9/2022, wife filed domestic violence case, white so-and-so case number with various allegations. Few of them are allegations of dowry. Paragraph 3 of the main DV application alleges that revision petitioner has been careless, greedy, and money-minded nature. Alleges that revision petitioner used to shout at the respondent with filthy language. Alleges that her alleges that at her respondent number 2's place of posting, the revision petitioner became furious and assaulted her with fist and blow. With these allegations, she wishes to restitute her conjugal life. And also that she, Lordship, wishes to stay in her matrimonial home. And with these allegations, Lordship. With these allegations, she wishes to restitute her conjugal life. There is every likelihood of cruelty by her and also manufacturing of evidence if she is allowed to stay in her matrimonial home, which can be helpful in her matrimonial cases. In the DV application, the respondent number 2 lied that her salary was 25,000 per month. However, an application made by the revision petitioner before the learned trial court, she filed her assets and liabilities, which revealed that her salary is 45,000 per month. Then in the cost title of the main DV application, she has stated that her address in Guwahati, but she stated that she does not have a place of residence in Guwahati. That the main application of the DV case in paragraph 14 of the respondent wife states that the child was born out of the wedlock, needs frequent medical attention, but she has not stated in the main DV application as well as in the criminal appeal preferred by the revision petitioner actually that medical attention of the child requires frequently, and also she has not submitted any documents regarding the same. The respondent number 2 has not submitted any document regarding school details of the child. Now, Lordship, date 10/6/2023. Wife filed petition being petition number 17 143 praying for her stay in her matrimonial home. This prayer was not made in the main application for application or affidavit under section 23 of the DV Act, Lordship. And one thing also to be noted, Lordship, that when this petition was filed, 17443, Lordship, I was not given any scope and opportunity. The date it was filed, the order was passed on the same date itself. I was not given an opportunity to file if I have any objection to, and on which the order was passed to leave the so that the wife can live in her matrimonial home or in the said household, Lordship. 10/6/2023, Line and Trial Court allowed the same. The impute residence order was passed. The order continued to stay in the said household. Continuity was already disrupted due to the cruelty and torture, physical and mental, meted out to the revision petitioner by the respondent number 2 wife. Hence, the order is bad in law and in facts. Observe that the contents of the main petition filed by the aggrieved as well as the DIR prima facie satisfy the domestic violence case indeed have taken place and likely to take place with the aggrieved. Now, Lordship, if the aggrieved person is allowed to stay in her matrimonial home, the order itself, Lordship, when I can see the impugned order, Lordship, of the JMFC, Lordship, it clearly states, Lordship, that court direct it states that peruse the contents of the main petition filed by the aggrieved as well as the DIR, which prima facie satisfied this court that domestic violence has indeed taken place and likely to take place. The order is contradictory, Lordship. Under that circumstances, what could have been done, Lordship? That she should be direction could have been that she should be given a place of residence if she at all does not have any place to reside in Guwahati. She wants a place in Guwahati to reside. Now, order could have been that the additional amount of this much will be paid for the rented house in Guwahati, Lordship, not in her matrimonial home, when the trial court itself satisfied that the court prima facie satisfied this court that domestic violence has indeed taken place and likely to take place. How under such circumstances, when prima facie it is proved, how an order can be passed that the quarrel can take place? And there is a timeline, Lordship, when the parties are not staying together. And I'll come to this one now, that the restitution case. The time of separation between the parties, how long she had been staying there. I'll take you to Lordship to page 45. That is the one, that is few paragraphs I'll read out from her restitution case. Timeline of separation between the parties.
Yes,
yes, paragraph 8, I'll start from there. The petitioner begs to state that in the month of April 2017, she joined the service and started to attend her school duties from Guwahati. The petitioner found it very difficult to attend her duties by traveling from Guwahati to Bongrabari, Mongoloi. So she stays in Mongoloi, not in Guwahati. Therefore, she took a rented house situated at Bongrabari, Mongoloi, and continued her job from the said rented premises. At this act of the petitioner, the respondent started raising objection vehemently. The respondent warned the petitioner either to leave her job or end her conjugal life. Even on 2-3 occasions, the respondent went to the rented premises of the petitioner and created unruly situation, thereby shouting at the petitioner using very filthy language. It is pertinent to mention herein that the respondent even physically assaulted the petitioner at her rented premises. On 9/9/2017, the petitioner along with the brother went to the rented premises of the respondent and demanded her to accompany them to Guwahati. But when the petitioner informed that without taking leave from her school authority, she cannot leave her place of post, the petitioner became furious and assaulted with her fist and blow and even tried to snatch the newborn baby. Facing such situation, the petitioner raised alarm, and consequently, the nearby people gathered at her place and prevented the respondent from assaulting the petitioner. Thereafter, as per advice of her neighbors, the petitioner telephonically informed that the whole matter to her, informed the whole matter to her parents. On being informed, the petitioner parents reached the rented premises at Bangrabari at around 8 p.m. The respondent even misbehaved with the parents of the petitioner and left the rented premises of the petitioner. Paragraph 9, that the petitioner begs to state on 11/9/2017, some police official of the Mongoloi police station visited the rented premises of the petitioner at Bangrabari and inquired about the incident that took place on 9/9/2017. The petitioner came to know from the police officials that respondent lodged an FIR against her before the Mongoloi police station.
Okay,
as
so where
FIR
are you
number-
taking us? What is the point of all this?
Yeah, the point is that the period of separation, that since 2017, April 2017, they have been staying separately. And after that, the incident happened when the revision petition, the husband demanded her to stay along with her at her matrimonial home. She refused to come back, and maybe some altercation took place. Police came, and the case registered by both the parties, Lordship. Now, what happened, Lordship? Because there is a separation between the parties. I'm at page 47, Lordship. On 3rd week of June, the wife, the respondent number 2, submitted. Surprisingly, on 3rd week of June 2018, that is almost more than 1 year after the separation, Lordship, the petitioner received a notice from the notice in the FCK civil case number so and so under Article 13(1) IAIB of the Hindu Marriage Act before the Principal Judge Family Court for divorce, Lordship. These points are because the separation started in the year 2017. The revision petitioner husband files one divorce case in the more than 1 year after separation. Files one divorce.
So what can we do now? She has come back to your house. Can we evict her now?
Is there a ground for
No,
revision?
I have not completed. Yes, Lordship. She has come back with an order of this honorable court, Lordship. Now, that order is not absolute, Lordship. It is the original order of staying of the proceedings that is being kept in abeyance, Lordship. Now, Lordship, there has been many judgments now. Why that started coming up of different high courts and Supreme Court as well, Lordship. Eviction of the aggrieved party. That is permitted under certain circumstances. Come up today. I am not with those judgments. I will be placing those judgments before this court, Lordship.
When?
I can submit it to your Lordship. Very short date, Lordship. I can do that.
All right, you finish your submissions.
Lordship. Now, this admission, Lordship, that there has been this submissions, Lordship, by the respondent number 2 wife, that there has been separation between the parties since 2017. Lordship, I admitted those in my written statement in the restitution case, and when there is allegations, serious allegations against me, it is absolutely difficult for me to reside with my wife, Lordship. And what can be done regarding the query posed by this honorable court, Lordship? I'll come to that. I have filed one additional affidavit, Lordship, dated 18/8/2025.
Yes.
Lordship, as she entered, there has been wrong verbal submissions have been made, Lordship, before this honorable court. That she has been staying in her matrimonial home. Thing is that the order of this court, an interim order, by keeping the original order, kept in abeyance, lordship. She has entered, yes. She has gone with her advocate and the police to her matrimonial home. Now, what she has done, she evicted, in fact, me and my physically disabled brother. I have annexed those documents, lordship. Our brother, and she occupied 3 rooms along with the kitchen and the bathrooms, lordship. Now, the thing is, the lordship, how many days she is staying there? There are allegations that there is no electricity, there is no water, but that is being that has to be with some concrete documents to prove it, lordship. Otherwise, that will not be admissible at this stage of the case, lordship. Now, she has been staying there. That which I have instructions from my client that she has been staying there maybe weekly, 1 day or 2 day, 1 night or 2 nights she has been staying. Just because she has to occupy it, she has taken those 3 rooms, lordship. I have stated in my initial affidavit that my brother, who is physically disabled, lordship, who cannot hear and who cannot speak, lordship. These are my complaints before the Protection Officer, Social Welfare Department. Then I have annexed here the Commissioner of Police. I have also annexed at page 176, Commissioner of the Disabilities, and the proceedings have started there, lordship. Then, lordship, I have also written to the Human Rights Commission. And at page, yes, at page, lordship, 179. Lordship can see the disability certificate of my brother. There's you can see in the serial in the down below, lordship, at the serial number 4, hearing impairment. She has started all kind of harassment to my brother. I am a school teacher. She is a school teacher. And in my absence, the 1 or 2 days she has been staying there in her matrimonial home, in my house, parental home, lordship. She has been creating harassment and havoc to my brother, and that has been a problem, lordship. If the trial court order, that is a prima facie, it talks about, because this interim maintenance are given on the whether the aggrieved party is able to speak something prima facie, prove something prima facie. Now, prima facie, the orders talks about that there has been violence, and there is likely to be violence, physical violence, or the quarrel between the parties. So that is why, lordship, my entire contention in the criminal revision petition, that I have filed my divorce case. She has been in my house now. The claim is that wrong submission, that she has been there for 1 year. It's not 1 year, lordship. She is there weekly, 1 or 2 days, and just because she has to keep the room, she is there. Now, I have filed what is the problem, lordship? Why it should be reverted to the original one? Because I have filed my divorce case, lordship. If she is allowed to stay there, I lose my grounds of defense in my divorce case, lordship. And now it is possible. The number of days she stays there, lordship, the ample number of evidences can be collected.
What's your ground of divorce? Desertion? Desertion.
Cruelty, lordship. Desertion and cruelty, both, lordship. So the desertion ground will not be that much applicable, because the separation between the parties in the year 2017 and the the divorce case was initiated in the year 2018. So there should be a gap of 2 years to take that ground. So under that circumstances, this ground of cruelty will prevail, lordship. And for that, if lordship is not satisfied, then I have to read out my entire criminal revision petition.
If you rely on cruelty, then allowing her to stay will strengthen your grounds. She will continue to commit cruelty upon you.
No, lordship, that will again create problems for me. Because I have to call police, she will be calling police. So that will keep, that will continue, Lords.
Yes.
So under that circumstances, if Lordship allows me to place the judgments before your Lordship, I can place those judgments under what circumstances an aggrieved person can be evicted even if she is allowed to stay, or she has been staying. And here, as the impugned judgment in the appeal, Lordship, as it is said that the filing a divorce case is not a ground for not allowing her stay in her matrimonial home. That is not the case, Lordship. Here, the divorce case is already filed. She has been staying outside for before she entered for 5 years, Lordship. There is no mental intimacy between the parties. There is no mental connection between the parties, Lordship. All possibilities quarrel, and when my child is there, I don't want those kind of quarrel happening. Thinking about the welfare of the child, Lordship. I don't want my child to see those kind of things at my home, Lordship. That is why there has been also submission that I do not talk to my child. Submissions are made on and off on different dates. I do not talk to my child. If I talk to my child, she stops her. So under that circumstances, if she stays in a rented house, I'm ready to pay something for that rented house, Lordship, and I'll be meeting my child outside in the presence of my wife, in a park or in a place on somewhere, Lordship. So this is my submission, and under all this context, Lordship. So under these circumstances, I pray before this honorable court.
What is the provision under the DV Act that permits residency in the form of a rented house? Which section is there?
That is, Lordship, under section.
Residence order is under section 19 and right to a residence is under section 17. So therefore, there's hardly a
It
provision
will
for
be
eviction.
considered under section 19, Lordship, for the right of residence, Lordship. And there is every application is there. Application is how that she may be allowed to stay in her matrimonial home, or she will be staying in a rented house, which will be arranged by the husband. That is the DV Act provision, Lordship. That provision is there.
Yes.
My final prayer is, Lordship, that my revision petition may be allowed, Lordship. There are many aspects which are not considered by the trial court and the appellate court. And and I have made this application, Lordship, under section 482 and also read with section article 227 of the Constitution of India. So that is ample power. To
Yes, yes, respondent.
Yes.
Lordship, he is not touching the grounds of revision at all. Revision can be done only on 3 primary grounds as we holistically look at it. If there is an error of finding, there is a big error in finding. If there's an irregularity in if the overall order is arbitrary or perverse. None of this is satisfied. The discretion used by both the trial courts the trial court as well as the appellate court is very much within the procedure, very much laid down what is benevolent, beneficiary, special act for women and children. Now coming to, so therefore he does not have any ground, and all his submissions never even touched the grounds in his petition. The grounds that he had taken, then.
But he has not touched
So
You
he
need
should
not
also
go,
not touch.
you reply to what he has touched.
When he has not touched, even I don't need to touch.
Yes.
He has touched, the main point he has touched is about separation. He is talking about separation. They were not separated. This particular submission itself says the husband is the one who deserted her. Simple. That was in page number, the dates that he had been submitting. 6/9, page number 17. So 6/9/2017, or when he's saying that there is a date of separation. Until that time, she was residing in Guwahati. Only on emergency conditions she was in this Moldoi because she was posted there. And this particular rented house was in fact rented out for her by her husband. On that particular day, on 9/9/2017, there was a small misunderstanding. The son had fever, she couldn't come back. So he went to go and get her. There was some small altercation. All the guardians of the school that she works in are nearby. There's a very significant point that I want to bring in here, which is not written anywhere, Mark, is that both her maternal and paternal grandparents belong to villages near Mongoldo. So she was working there, although she was posted there. There were people who knew her, people who knew her grandparents. So she was within that community that belonging to her maternal side as well as paternal side. So she was not an outsider there. And in fact, there was an Alto car which was hired by the revisionist. With that car, she used to travel every day during pregnancy, even after the baby was born. There was a magic ones rented out. The number is also given. The number of the vehicle is also given. I'll make a written submission about that since we are short of time today. And most interestingly, she used to not only live here, she used to look after them as well in the same place. And she's residing in those 2 rooms. There's a veranda and 2 rooms, not 3 rooms. 1 veranda and 2 rooms. 1 room is her kitchen and dining, and 1 room is her bedroom. And there are 2 people, she and her son. And that is the matrimonial part. When she got wedded, when she got married, she came and started living there in that part, where eventually the court has asked her to go and live. So she's very much within her rights, constrained, and a very law-abiding wife. She's the last person on earth, even I can vouch for her, that she will be going around shouting or quarreling with anybody. It is absolutely not true that she's living there for only 1 or 2 days. In fact, 1 or 2 days, she goes to help her old parents. That's it. And look after her family sometimes. But mostly she's residing here. Her son's school is also quite near to Kahilipat. So he goes in a school van. She comes down the hill, puts him in the school van. So my learned colleague's argument about this separation, about her rights, all this doesn't hold any water. Now coming to the point of what they have alleged in the divorce case and what they have alleged in the conjugal rights and all this is not a great matter of this revision court. Reason being, there are courts, their proceedings are going on. The court will adjudicate, and the revisionist hardly appears. There's 3 or 4 dates in a year, he doesn't go. He's not paying maintenance on time. Almost 70,000 maintenance was pending. Last date he paid 48, remaining still pending. In such a situation, can he pay the rent? We do not. Most importantly, he's very neglectful. Lordship, he's very neglectful, and this is not my observation. This is the observation of the court. As my learned colleague already read out the decisions on which the matter was adjudicated in the appellate court, I'm not going to make very detailed submissions on those, because as such, I seek your permission to give a written submission. Because there were many small points that he had touched, which I believe should be addressed in a written submission. However, just coming to the point number in page number 134. And The appellant repeatedly requested her to stay at the matrimonial home, but she did not pay heed. And as such, the appellant once went to the rented house of the respondent. If he is repeatedly asking her, what is preventing him from accepting his wife and child now? Other than ego. If he was the same man who wanted his wife and child back, he should be the same man now because nothing has changed. He's still there. On the contrary, now she is posted in Guwahati. After working there for about 12 years, since 2024, she's posted in Guwahati. She does not want to stay in her matrimonial home. She's a married woman with a child and very much residing in her husband's house. Now, obviously, there is a big scope of them coming together as well. I do not agree with my learned. Amen. If this incident on 9/9/2017 separated them, something in the future may also bring them together. Why shouldn't we give the family a scope? We have to be optimistic. So on this, I do not want to take the court's further time. So I'm seeking your lordship's permission to submit a written submission. But these allegations that she is quarreling with the disabled brother is absolutely wrong. There's one very important and significant event that had happened on that day, 9/9/2017. So when both the brothers, that is the revisionist and his younger brother, was only having one small problem, that is hearing impaired. So he's physically really fit, a tall, big man. I've seen him, I've met him. So there is no way my short-statured, not very strong laid client can hit him or quarrel with him in any way. On the contrary, she's very kind to him. But I was just referring to this, that the people in the surrounding area, they are willing to come and help them because they had somehow managed to make them sign a homaznama. So when everybody gathered to resolve the problem, they had signed a homaznama. So they are also willing to come and testify. So let the trial go on. And as such, this matter is in the trial court for final disposal. At this stage, when the cross is due, when so many things are going on, there is no point for
Trial means trial in the DV case.
Pardon?
Trial in the DV case.
Trial in the DV case. It's in the cross stage. Her cross is done. The cross of one or two more PWs is pending. So all we are praying for is let the trial court decide within whose power it is. Because as such, there is no revision jurisdiction from the events, and there is nothing perverse in the orders as well. On the contrary, the orders have gone at length and detail of what is the definition of a shared household, how and who is entitled for shared household. All of this have been addressed in detail. Since all of these have been addressed in detail, I want to make this in the written submission. How and why?
You are not required to bring any facts here. We are a revisional court. We are not going into evidence and discussing
Yes.
did what.
Yes.
We are only
There's nothing
going to pronounce on the
order.
legality of the impugned order. That is all.
Yes, and it is a continuation as well. So therefore, I believe there is nothing in this petition which will
We are not
demerit
going
our
to say
trial.
what should have been done, what should be done, how to proceed. We are not going into all that. This is
Yes.
the revisions.
However, our small prayer is that let them bring their grievances to the trial court,
Yes, all right. We are
which is the appropriate forum, not to the revision.
Yes.
Lordship, just give rebuttal if she has complete.
Yeah, can give your rebuttals. I have two more.
You complete.
So you.
You completed then.
As a petitioner has to get a scope. So he has pointed out that on evicting the wife, he's also going to evict his minor son. So is he going to evict his son and send him to go and live in a rented accommodation? He's forgetting it's not about his wife only. What is his duty as a father to his son? There's a larger scope of this act. They want to protect the interest of the child. They want to protect the psychology of the child. They want to protect the mental health of the child so the child grows up in a safe environment, knowing that he's loved and wanted, and how to provide it. Therefore, the state also has a duty. Are we all going to violate the state's duty, who's already done their job and done their job beautifully? So here, Lordship may take into account the rights of the son as well, who is a minor, living with his mother, living in his father's house, occupying only 2 rooms. One is their dining cum kitchen and study. Another room, very small rooms, is a bedroom with all their belongings. And one is a small veranda.
Lordship, the submission made by the learned counsel, the respondent that there is no revisional jurisdiction and a revision can be allowed when there is an error of finding. Lordship, not even a page order, page 97 of the criminal petition law, the order is not even a page. And what findings are there, Lordship? No findings are mentioned there. It's simply the main petition filed by the aggrieved person as well as the DIR, which prima facie satisfied this court that domestic violence has indeed taken place and likely to take place. And before that, all mentioning about the various.
But that you have challenged in appeal.
Yes.
Appellate court has decided.
Yes, decided, Lordship.
And
Appellate court order is not a single page order.
That is not a single page order, but where the appellate court has gone wrong without considering certain facts, Lordship, even the appellate court that I have submitted in my, what the appellate court did not submit in my ground, I have submitted with all the details of all the dates, Lordship.
This is only an interim order. The final will come.
And then
you are dissatisfied, you can come to.
And then, Lordship, and what my submission would be at this juncture, Lordship, that the residence order can be allowed as the trial court order and the appellate court order. It did not touch many of the facts, Lordship, for allowing it. So my submission would be that the residence order allowed that can be withdrawn, that can be vacated by this honorable court, and that can be, if at all, residence order can be provided, let the trial court provide it after the trial is over. Because lots of things are to happen here, Lordship. In the trial, many things can happen.
I have huge objection in his submission.
And then, Lordship, it has been reiteratedly submitted that the wife has, that the appellant has been requesting her to stay in her matrimonial home. Earlier, after filing the divorce, why he would be allowing her to stay in her matrimonial? And after all the bitterness, after lodging of FIRs by both the parties, Lordship.
No, we have not lodged any FIR.
And then, Lordship, Lordship, it is claimed, it is also submitted before this court that he has been staying here for 1 year, staying in a matrimonial house for 1 year, and it is also submitted that things can go in a reverse way, like a uniting.
Those are matters of trial. We cannot go into all that. You say, she says she's staying for 1 year. You say she's not staying. She's staying for 1 or 2 days. How did this court decide all that?
Lordship.
We are only on the legality of the order.
Lordship, I have a small submission.
Eviction of minor son, Lordship. I don't know, as I have submitted, I don't want to see my son see the quarrel between the parties.
There is no quarrel.
And I will not be submitting about the facts, but Lordship,
can I make a small
revision?
Yes.
This revision code at least can see the dates and events I have submitted, Lordship, and which are not touched upon by the trial court and even the appellate court, Lordship.
They will be coming to it.
That can be seen by this revision court, Lordship. What is not considered during when the appellate order passed its judgment, Lord.
It's not a judgment. Lordship, I have a small submission to make. My learned friend here is erroring in the technique and procedure adopted for the Domestic Violence Act. The Domestic Violence Act is very much for not making a woman and their children destitute. He's forgetting that. He's forgetting that part at all. Reason being, here, as we know, many times a married woman, if she's not in her matrimonial home, she has so many questions. And she is also having two brothers who are not married yet. She does not want to go and become a burden. And she's married to this person. They had a conjugal life. They have a son. Why is he bringing in things which are not necessary, particularly not necessary at this stage or with this petition? It is very much important for my learned colleague here to accept the fact that the order passed by the trial court was an interim order. And the interim order
Yes, yes, we have noted that you have.
very
need to
much
keep
within.
repeating it. Yeah, you want to file submit?
I'll be,
submit in-
Lordship may give me 1 week's time only for submitting the written submission.
Then we have to again list it. The written submission is required now. We're not
A
going
small
to.
one, just to touch the points that he is highlighted.
Quite hard. Both sides at length. Is the matter again on? To enable. Done it till the resident to submit. Written submissions. Also. Turn it to enable learned counsel for the petitioner to. So are you going to submit today itself, judgments?
Not on the next.
Judgments of Apex Court.
12/11. 12/11.
Heard.
Okay.
My lord.